Good afternoon and welcome to the third meeting of the Legislative Commission in calendar year 2024. I'm going to apologize because I did wake up with a little bit of a lost voice, so bear with me today. We are going to begin by doing our roll call. So Madam Secretary, will you please call the roll?
Assemblywoman Anderson?
Present.
Assemblywoman Backus? Present. Assemblywoman Bilbray Axelrod?
Present.
Assemblyman DeLong?
Present.
Assemblywoman Hanson?
Here.
Assemblywoman Monroe Moreno?
Here.
Senator Daly?
Here.
Senator Hanson?
Here.
Senator Krasner?
Here.
Senator Stone?
Here.
Vice Chair Harris?
Present.
Chair Cannizzaro?
I am here. We do have a quorum present. Before we get going here today, I'm going to go over just a few housekeeping items. I would like to ask everyone who is here to testify, whether you're in person or you'll be joining us via phone, to please state and spell your name for the record before you begin testifying. If anyone here would like to receive a copy of the Commission's agendas, minutes, or reports, you may be added to our mailing list by following the links on the Legislature's website or by providing information to our staff who are present here today in both Las Vegas and Carson City. Contact information as well for staff is listed on the Legislature's website. In addition, please keep in mind that we do accept written comments, which may be emailed or mailed before, during, or after the meeting, and the information regarding where to send written comments is also on the website and listed on the agenda for this meeting as well. We will go to item number 2 on our agenda, which is our first public comment period. We will be accepting public comment at this time from persons here present in the Grant Sawyer building. We have 3 seats up here at the dais. If you would like to give public comment on any of the items we'll be hearing today, now is the time to do that. We will also have another public comment period at the end of the meeting. We'll let you guys fill up these seats here. We also have seats available in Carson City for anyone who is in Carson City and wishes to give public comment. You can go ahead and fill those seats. We'll begin here in Las Vegas, then go to Carson City, and then we will move to the telephones. Excuse me, as reminders for those of you who will be testifying with us today, there will also be a second period of public comment following the end of the meeting after our business. So if you wish to provide public comment at that time, you can certainly join us once we get to that second period of public comment. Please also remember that comments during public comment will be limited to 2 minutes per person. If you don't finish what you have to say in that 2-minute period, I would encourage everyone to submit written comments in full of anything that you weren't able to let us know at the time. So we will go ahead then and begin. As a reminder, please make sure you identify yourself. Make sure that you do sign in on the clipboard so we have contact information in case we have any questions. And we will begin here. Whoever would like to begin first, remember we'll start 2 minutes public comment. And once folks here who are at the dais in Las Vegas are finished with their public comment, if there are other folks here in person who wish to give public comment, you can come and fill these seats. Whoever would like to begin. Mr. Kennedy, can you hit that microphone button in front of you?
Oh, I thought it was on. Okay.
There we go.
There we go.
Thank you.
Kirk Kennedy, Kirk Kennedy. I'm a Nevada counsel for the Fazuba Massage School, and I'm commenting regarding regulation R017-24, which is the regulation from the Nevada Massage Board. I'm here today to make some brief comments that are impacting my client's school and the students and graduates of that school. Recently, the Nevada Massage Board met on May 9th to consider changes to some of the requirements for applicants to get a massage license. And certainly that's within their right. They have that power to make changes to the Nevada Administrative Code. The code sections they made changes to were NAC 640C.052, which increased the hours that are required for an applicant from 550 to 625 hours. And the matter at issue, the NAC provision 640C.050E, the Massage Board voted to remove the ITEC program, which provides a national exam. An examination requirement is required for all applicants, and the Massage Board voted to remove that program. The effect of that removal was dramatic because my client's school and perhaps other massage schools in town as well I have students who have signed up for, paid, and enrolled in the ITech program to successfully complete the program and get their national exam requirements done. ITech has been approved by the Nevada Massage Board since at least 2018, when the last prior amendment was made to the Nevada Administrative Code. This action in changing or removing ITech, certainly it's allowed, but the board apparently did not vote on when that would take effect. They did have an effective date regarding the change to the number of hours for the school. They made that effective June 30th, but they failed to vote or deliberate on when they should make the ITech implementation effective. And this has caused confusion and concern with a lot of existing students and graduates from the school because they have pending applications where all of a sudden now the program they paid for may be is unacceptable by the board if this is accepted, if this provision is passed today. What we're asking is very simple. We're just asking the commission to remand this matter, at least in part, as to have them redeliberate the issue of ITech.
Kennedy, if you could go ahead and wrap up because you're
basically redeliberate the issue of ITech and to consider granting a further extension of time to allow for the termination of the program so as not to adversely impact the existing students. Thank you very much.
Thank you. Whoever wants to go next.
My name is Jerry Hsu. Good afternoon, dear commission members. I'm here today to address a critical concern regarding the LCB file R017-24, which pertains to NAC 640C and regulates massage therapy in the state of Nevada. The adoption language of this file lacks clarity, transparency, and due process, particularly concerning the sudden elimination of an ITech qualification. Despite its specific deadline, it was dismissed as irrelevant by the board's legal counsel at the end of the last public hearing meeting. Stakeholders were not consulted, their rights were disregarded, and no prior notification or transitional periods were provided. Behind me sit individuals. The last three rows, we have about 3,000 students about to be affected, from a very underrepresented group who have invested significantly, tens of thousands of dollars, their time, effort, to become a licensed massage therapist under Nevada regulations. Some of them already completed qualifications, the others in progress. However, signing this file today could invalidate their qualification, jeopardize their careers, and hard-earned progress. Most importantly, it undermines their spirit, the very spirit of self-motivation and dedication that the state should encourage and protect. Dear commission members, you have the power to act to help these individuals. Taking action means demanding clarity, transparency, and a due process from the massage board. Inaction means withholding your signature on the file until these conditions are met. Thank you for your consideration.
Thank you. And just as a reminder to everyone who's going to testify, please spell your name for the record so that we have the appropriate spelling.
Hi, good afternoon. My name is Yolanda King, last name K-I-N-G, and I am the president of the Nevada Taxpayers Association. My public comments concern Agenda Item 4, Administrative Regulation 150-22. For some background information, the existing law allows for religious, charitable, and educational organizations to be exempt from paying sales and use taxes. An organization that wishes to claim this exemption must apply to the Department of Taxation for the letter of exemption. If it is determined that that organization qualifies for the exemption, a letter of exemption is issued. Regulation 150-22 makes changes to clarify that the exemption effective date is upon issuance of the exemption letter issued by the Department of Taxation. On the March 27th workshop, I provided public comments and emailed the Department of Taxation requesting a change to this proposed regulation. I suggested amending the language to state that the exemption approval should be granted upon submitting an application for the exemption to the Department of Taxation. This approach is similar to the IRS process. Regulation 150-22 will delay exemption benefits, causing organizations to pay taxes during the processing period. A better approach would be to grant approval upon submittal of the application with the condition that if taxes are owed, if the exemption is denied, that the taxpayer would be responsible for paying for those taxes during the period. Again, this is an approach that is similar to the IRS exemption process. When the Tax Commission reviewed the regulation, my comments from that workshop were not included in the impact statement on the small businesses. Additionally, I submitted a formal letter to the Commission requesting to change the regulation. However, because my letter was not submitted within 2 weeks of the May 8th meeting, my letter requesting for an amendment was not included in the backup information for the Tax Commission. I also noted I did make public comment at the Nevada Tax Commission with recommendations of an amendment to this regulation. The Department of Taxation did voice their concerns about the amendment. However, it was at the Tax Commission meeting. That was my first time hearing of their concerns, as well as the first time that the Tax Commission heard of the concerns for the Nevada Tax Commission. So given the significant implications of this change, of what it will have on the nonprofit organizations, I respectfully request that this regulation not be approved today, and instead I urge you to remand it back to the Nevada Tax Commission for a more thorough vetting to fully understand and address the concerns of the Nevada Taxpayers Association. This is a crucial issue that requires careful consideration and a fair resolution. And my comments have been included as part of the backup for public comment today, and I thank you for your time.
Good afternoon, Chair Canizera, members of the Legislative Commission. For the record, Paul Muradkin, Senior Vice President of Government Affairs for the Vegas Chamber. The Chamber is in support of the State Ballot Question 1 explanation language as it relates to your agenda item 5A, which, as you know, proposes to amend the Nevada State Constitution relating to the NC Board of Regents. For full disclosure to the Commission, the Chamber has been in support of this measure at the state legislative sessions as SGR 7, which received bipartisan support in 2021 and 2023. The Chamber believes that the language as drafted is a manner that allows voters to have an objective decision with a clear understanding of the intent of the ballot question. The pro and con arguments both are a result of compromise and balance, and the Chamber believes that this will allow the voter to make their decision with the necessary arguments presented in front of you today for your consideration. The language makes clear that the ballot measure is to remove the regents from the state constitution and place NC regents in the Nevada revised statutes. As noted in the explanation as in front of you, the constitutional amendment does not change the board from being elected to appointed, and voters do not lose the right to vote for their regents. Thank you for your time and consideration, and we hope we will have your support to move the language forward today. Thank you, Madam Chair and members of the committee.
Good afternoon, Chair Canizaro, Vice Chair Harris, members of the Legislative Commission. For the record, my name is Alejandro Rodriguez, R-O-D-R-I-G-U-E-Z, Director of Government Relations for Nevada System of Higher Education. On behalf of NCHU, we'd like to thank you for the opportunity to provide comments on the original proposed ballot language. Consistent with NRS 281A.520, my comments and requests for revision are not intended to support or oppose this ballot initiative and should not be construed as such support or opposition. We appreciate the revised version, removing certain factual inaccuracies related to transferability between our institutions. We also appreciate an effort to provide more transparency to voters about the legislature's current oversight ability. We do believe, however, the condensation section requires greater transparency and unbiased language so voters are well informed about the implications of their decision. As noted by some faculty members in public comments, Question 1 explicitly removes the election of regents from the Constitution. While Question 1 does not change current statutes and states in the condensation that it will not alter the statutory election process of regents, this assurance is misleading to voters. The potential for future legislative changes remains a very real possibility, making the statement seem like an argument for passage. We agree with the public comment that the condensation should include a clear statement about how Question 1 would enable future statutory changes by the legislature. As previously stated, no matter the outcome in November, we look forward to continuing to work collaboratively with the legislature to enhance the governance and oversight of public higher education in Nevada. NC remains committed to fulfilling its mission of providing quality education and fostering academic excellence across its institutions. Thank you.
Try hitting, yeah. And try hitting the microphone button. It should say mic.
There it is. Okay, sorry.
There you go. You're good.
My name is Nathan O'Hara, Nathan, last name O''Hara. I want to make sure everybody here understands what's at stake today with regard to Regulation R017.24, which is on your consent calendar or consent agenda. For the better part of a decade, the Nevada Massage Board has accepted the ITEC exam as a qualifier for massage licensure. Recently, they decided not to start not accepting it anymore. Unfortunately, the board, during that meeting, failed to set a cutoff date for pending applicants to have completed that exam in order to use it as part of their licensure application. If you approve R017.24 today in its current form, this will immediately, now and today, stop the massage board from processing any applications from a significant number of people who have already completed all of the current massage licensure requirements, including that exam. According to the director of the massage board, once these changes to regulation are approved by the commission, we will no longer be able to approve applications where the ITEC was taken as the exam. Now, these applicants have already completed and passed a very comprehensive qualifying exam process in full compliance with current Nevada regulation, 640C.050-E. As written, R017.24 would retroactively, and I think unfairly, nullify their achievement. If you approve this regulation in its current form, your action will cause substantial economic harm to these individuals with no benefit to anyone, really. We're asking that you remove R017.24 from the consent batch of regulations on your agenda, and that you ask the massage board to revisit this proposed regulation to set a fair cutoff date for actual applicants to have completed the ITEC exam. Thanks very much. I appreciate your time. Who do I give this to?
Great, thank you. You can, we'll grab it from you. Thank you so much. We appreciate it. Is there anyone else here in Las Vegas wishing to give public comment at this time? Seeing no takers, I don't see anyone at the dais in Carson City, so we will move to our phone lines. BPS, if you could, we have callers who are ready to testify. Connect them with us. As a reminder, please state and spell your name for the record, and remember that your comments will be limited to 2 minutes, but we're happy to take any written comments over and above that 2-minute period. So BPS, I will turn it over to you.
Thank you, Chair. To provide public comment, please press *9 to take your place in the queue. Again, if you wish to provide public comment, please press *9. Caller, you are unmuted. Please go ahead.
Hi, Chair, members of the committee. My name is Lindsay Harmon. That's spelled LINDSEYHARMON for the record, representing Planned Parenthood Votes Nevada here today. We are supportive of the language as drafted for question 1 pertaining to agenda item 5A, and that is it for today. Thank you.
Chair, we have no additional callers at this time.
Great, thank you, BPS. As a reminder, for those of you who are joining us in person or might be watching us online, we will have a second period of public comment before we adjourn today. But with that, we are going to move on to the next item on our agenda, which is agenda item 3. It is the approval of minutes. Commission members, you have in your packet and in front of you the draft minutes for the Legislative Commission meeting held on April 18th, 2024. These draft minutes are also available on the legislature's website. So let me first ask if there is any discussion on these minutes. And I am not seeing any discussion. At this time, I would accept a motion to approve the minutes of the Legislative Commission meeting from April 18th, 2024. So moved by Senator Harris. I have a second from Assemblywoman Backus. Any discussion on that motion? Seeing none, rather than do roll call votes today, I'll ask to do a voice vote, and we'll be able to hopefully manage our folks who are joining us remotely. But for those in favor of approving the minutes, please signify by saying aye.
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 Any opposed, please say nay. Hearing none, the minutes are, no. Hearing no opposition, the minutes will be approved unanimously by this commission. And that brings us to agenda item number 4. This is the review of our administrative regulations. We are joined today with our legislative counsel, Asher Killian, who is sitting next to me here in Las Vegas, and he will be able to assist us with this item. There were originally members 42 regulations submitted for consideration under item 4 today. Please note that our 100-23 and R013-24 are being removed from our agenda. Those regulations were granted early review at our last meeting on April 18th and thus require no further consideration by this body. The remaining 40 regulations that are on today's agenda were submitted for approval pursuant to NRS 233B.067. These regulations are all contained in the notebooks on your desk. And they also are posted on the Nevada Legislature's website under the tab for this meeting. You can find that tab by hitting the View Events button in the upper right-hand corner of the Legislature's website homepage. There's also a public copy of the notebooks on the sign-in tables both here in here in Las Vegas and down and up in Carson City. At this time, I do have several regulations that were requested to be pulled ahead of the meeting by members of the commission for further consideration. I'm going to read those regulations. Please make note of it on your list, and then I will ask if there are any additional regulations that members of this commission would like to have pulled for further consideration. The first one that we have is R162-22 for the Board of Wildlife Commissioners. The second one is R199-22 for the Real Estate Commission. We have R025-23 for the Division of Industrial Relations in the Department of Business and Industry. R081-23 for the State Treasurer. R097-23 for the Commissioner of Financial Institutions. R136-23 for the Commission on Ethics. R017-24 for the Board of Massage Therapy. R025-24 for Peace Officers Standards and Training Commission. R047-24 for the Board of Public Employees Benefits Program. R061-24 for the Administrator of the Division of Outdoor Recreation. And that is the end of my list for regulations that have already been requested to be pulled for further discussion. I'll start here in Las Vegas. Are there any additional regulations members of the commission would like to have pulled? We are going to add to that our 150-22 for the Nevada Tax Commission. We'll go up to Carson City. Are there members of the commission that would like additional regulations other than the ones I've already listed to be pulled for additional consideration? I'm not hearing anything in Carson City. So we will give you a moment. We'll move to
one second.
Skip,
1 second.
excuse me,
I don't have
Secretary
any.
Daly.
Apparently, we don't have any. Thank you.
Madam Chair? Madam Chair, this is
Senator
Jeff
Stone, please hang on just 1 second. We're in Carson City
Sure.
still.
Oh, you bet.
No additional regulation to be pulled. Thank you.
Okay, great. Thank you, Senator. All right, we will move to those of our members who are joining us remotely. We will begin with Senator Stone, additional regulations for consideration.
Thank you, Madam Chair. The first time I've kind of done this remotely, so forgive me. I had my hand raised. I didn't know if I was going to get missed or not. So I think I have the numbers right, and I'm not sure if you mentioned, I think you might have mentioned one of them, but just to be sure, R156-22B, R093-23A, R100-23. Thank you.
Senator, I have in addition, you're requesting for R156-22 for the Nevada Tax Commission to be pulled. And I got the last one, R100-23 for the State Board of Pharmacy. What is you had a third that I missed.
Yes, please. R093-23A. You might have said that one.
Senator, we don't have on our list R093-23.
So forgive me because I have my own notes here. This is regarding the issue of elevator operability. If you could maybe have staff identify that agenda item number.
R025 is what I show, -23A.
Thank you.
We
That's
already
probably
have
it.
that one pulled.
Great. I thought you did. So sorry about that. Thank you. Appreciate it.
Is there anyone else joining us remotely from the commission who wishes to have additional regulations pulled? I'm not seeing any. Okay. Then before we begin, I'm going to go through the final list of those regulations that were requested to be pulled for additional consideration. And members of the commission, if we missed any, please let us know. So those to be pulled for additional consideration. So if you are here for these agencies, you will have to stay with us a bit longer. We have R150-22 for the Nevada Tax Commission and R156-22 for the Nevada Tax Commission. We have R162-22 for the Board of Wildlife Commissioners, R199-22 for the Real Estate Commission, R025-23 for the Division of Industrial Relations, R081-23 for the State Treasurer, R097-23 for the Commissioner of Financial Institutions, R100-23 for the State Board of Pharmacy. I apologize. The R100-23, Senator Stone, I believe that was the third one of your requests, but that one is one of the ones that we already approved for early consideration back on April 18th. So that one was pulled from our agenda. We will not be hearing that one today. All right, so the next one we have pulled for additional consideration is R136-23 for the Commission on Ethics, R017-24 for the Board of Massage Therapy, R025-24 for the Peace Officer Standards and Training Commission, R047-24 for the Board of Public Employees Benefits Program, and R061-24 for the Administrator of the Division of Outdoor Recreation. Anything we missed? I'm not seeing any hands go up or folks letting us know we missed anything. Okay. Then at this time, we do have the remaining regulations on our agenda. R058-22, R098-22, R134-22, R141-22, R003-23, R031-23, R032-23, R054-23, R060-23, R077-23, R079-23, R096-23, R098-23, R101-23, R103-23, R105-23, R108-23, 119-23, R121-23, R126-23, 135-23, R014-24, R024-24, R049-24, R051-24, 052-24, R054-24, and R060-24, which are not being pulled for additional consideration. So I would accept a motion to approve those regulations.
Move
Madam
those
Chair,
recommendations.
Senator Harris, you have a motion.
Madam Chair, I would like to move that the regulations, as stated by you so beautifully, be approved.
I have a motion from Senator Harris. I have a second from Senator Stone since he chimed in. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
Aye.
Aye. Aye.
Any opposed, say nay. Hearing none, that motion is approved. Those regulations which were not pulled for additional consideration will be adopted by the Legislative Commission. If you were here for any of those regulations, we will give you the space to head on out. You are done with us for the day. For those of you who will pull for additional consideration, you're going to hang out for a little bit. Okay. We are going to begin our follow-up discussion with R 150-22 for the Nevada Tax Commission. We will invite those who are with us from the Tax Commission to join us. And once we are seated, I will turn it over to Assemblywoman Monroe Moreno for the Tax Commission. I think we have some questions regarding some of the statements that we heard during public comment.
Thank you, Madam Chair. I was not going to pull this item until we heard the public comment, and I just wanted to get a little bit more explanation in reference to the comments that were made before we actually vote on approve or to remand it back for further discussion, and why the comments from the presenter was left out.
Do we have somebody remote from the Tax Commission or in Carson City?
Yes, good afternoon. Can you hear me?
We can hear you now.
Thank you. Good afternoon, Madam Chair and Commissioners. My name is Sarah Glazner with the Nevada Department of Taxation. That's Glazner. And I'm sorry, I'm having difficulties with the video. There we go. Thank you. Can you hear me?
Good afternoon. We can hear you. Thank you for joining us. Were you able to hear the comments that were made during public comment about this item on today's agenda? And could you address those comments?
Yes, I can. I'm so sorry. 1 second, please. I'm sorry. I'm having technical difficulties with the Zoom.
We completely understand.
Okay, Ms. King, she did provide public comment for the Nevada Tax Commission. It was not delivered within the 2 weeks, but we had the same public comment for that during the workshop. And what was explained to the commissioners is that the RCE exemption, the religious charitable educational exemption in Nevada is significantly different than the ones for the IRS. The requirements are different, and our form specifically notifies all applicants that the requirements are different. And they did present this at the Nevada Tax Commission, and the department's response at the public hearing with the opportunity for discussion and questions were made, and the commission made a knowing affirmative decision not to adopt those suggestions based on the differences in the exemption in Nevada and the potential negative impacts to the department.
So currently, the exemption, and I'm not sure which camera you're looking into, but we see the side of your head. There you go.
I'm so sorry. The Zoom, it's just everything. So sorry.
That's fine. So currently, the way Nevada's tax exemption is written, it's different from the federal exemption. So is the state receiving monies from those organizations now, tax dollars from those organizations now, and while they're waiting for their exemption to be approved from the state currently? I just want to make sure that I understand it correctly.
If it's, I would say yes, but what these are is the religious charitable educational exemptions. They send in their application and it is reviewed and either approved or denied. It's very strictly, it's very strict by statute, whether to qualify, and whether you qualify for religious has separate criteria, and so does charitable and educational, and all of those need to be met. They're not the same as the IRS. The requirements are specific to our statutes, but the IRS does allow the provisional approval, if you will, and the state of Nevada does not. And we can't, it's bound by statute. And so that's why we explained to the Nevada Tax Commission our stance and why we can't continue the way that the Nevada Taxpayers Association would like to, because it's a completely different, it's significantly different than the IRS exemption rules and regulations.
So just make sure that I understand you correctly. If we were not to adopt the regulations as presented today, we would be in, I wouldn't say in violation, but there would be a difference between what we have currently in statute and the practice that we have been doing. So this would make us more aligned with what our statutes are. Is that correct?
Yes, the only thing that this regulation is changing or updating is that the application, the religious charitable educational exemption, is not valid until it's issued. So, and that you can't go backwards for a refund. So there were several times where taxpayers would say that, they ask for an exemption and then they want it backdated all the way back to when they started but never applied. We wanted to put in the regulation to make it clear that the exemption is not valid until it's approved and they get their exemption letter. And what the Nevada Taxpayers Association would like is for it to be provisionally approved right when we get the application, before seeing if they qualify or if they abide by the statutes. So the only thing changing in this reg was just to make it clear that it's not retroactive and that your exemption does not start until it's issued by the department. That's the only thing that we wanted to update on the reg, just to make it clear for the statute. So yes.
Thank you so much for the clarification. Thank you, Madam Chair.
Assemblywoman Backus.
Thank you so much. And I just wanted to clarify and do a follow-up to my colleagues' questions. So just so I understand it right now, the Department of Tax is not issuing refunds and enforcing the exemption at the date of the letter, so that the changes that are proposed in this regulation aren't changing the practice that the Department of Taxation is doing at this time.
That is correct.
Madam Chair, if I may have one last follow-up. And so is that why, because there's been no change, it hasn't triggered an expense to the businesses because there's really been no change from the way the division has been operating as of current, and then how it will operate under this new regulation?
Correct.
Any additional questions from members of the commission? Not seeing any. I'm not seeing any. Assemblywoman Monroe Moreno, a motion to approve. I have a motion to approve by Assemblywoman Monroe Moreno. Is there a second from Senator Harris? Any discussion on the motion? Seeing and hearing none, all those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Any opposed, say nay.
Nay.
Hearing none. Oh, sorry, go ahead.
Nay.
I have a nay from Senator Stone and a nay from Senator Krasner. Okay, seeing the majority is approval, our 150-22 for the Nevada Tax Commission will be approved. Don't go anywhere because we're going to now hear our 156-22 from the Nevada Tax Commission, which I believe was a request from Senator Stone. So Senator Stone, will turn it over to you.
Thank you, Madam Chair and colleagues. Regarding this regulation, we saw some testimony, at least I saw online, from Trey Abney and from the Restaurant Association that claimed that this was going to be a large burden to small businesses. And I was just curious if staff was able to resolve many of the issues to mitigate some of those burdens to these small businesses that are struggling these days.
And I think you might be on mute. Thank you.
So sorry. Can you hear me now?
We can hear you now.
Okay, thank you. Sorry, Senator Stone. Again, Sarah Gleasner, Nevada Department of Taxation, for the record. Yes, we did have a meeting with Trey Abney as well as the Restaurant Association and explained, and even at the workshop, and there was no issue after that. All it's doing is when the NRS was changed back in 2013. I'm sorry, I have my notes right here. The NAC was never updated to align with the NRS. So all we did is just clarify, we just added to the NAC what is in the NRS. That's all we did. And we explained that to them, and they understand now.
Thank you so much. I appreciate that. And thank you for working with them and with that, Madam Chair, at the appropriate time. I'm happy to move the item.
Of course.
Thank you. Any additional questions from members of the commission? Hearing none, I do have a motion for approval from Senator Stone and a second from Assemblywoman Backus. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Any opposed, say nay. Hearing no opposition, our 156-22 will be approved unanimously. And I believe that does it for the Tax Commission. Thank you so much, and we appreciate you being here to answer our questions. We will move to the next regulation on our agenda. It's our 162-22 for the Board of Wildlife Commissioners. And we will let them get joined with us. I see some folks moving in Carson City. We'll give you a minute to get settled. And we will begin with, I believe, Assemblyman DeLong had some questions on this. And then I believe also Senator Daly, I think, had some questions. So we'll start with you, Assemblyman, whenever you're ready.
Thank you, Chair. I appreciate it. Thanks for being here in person. I appreciate that. In going through this regulation, it's based on the planning and zoning chapter of NRS, not the wildlife or habitat chapter. And under NRS 278335, there is a basically an exemption from going in front of the Department of Wildlife if it is an infill property which is proposed on a vacant or substantially vacant tract of land that is surrounded by land that is already developed. It's a reasonable interpretation that that language in the NRS is related to an infill parcel and surrounding parcels that have human development on it. However, when we go to the regulation under Section 5, for the definition of substantially vacant or vacant land, we bring in a wildlife and a habitat issue in determining what is vacant. And that, to me, there's an internal conflict there. We're bringing in a wildlife and habitat issue to a land use planning and development section of our NRS. And taken to its limit, any parcel that has grass or a tree would be habitat. And therefore, essentially, only bare dirt would be able to be considered vacant. And so, did you guys review that? I think that's internally inconsistent and inappropriate.
Yes, Jasmine Kleiber with the Nevada Department of Wildlife, for the record. We did review that at length, and we had solicited much public comment on that as well, and worked with the Legislative Council Bureau to identify what is actually not a definition, but an interpretation for the express intent of reviewing for wildlife impacts. It's not uncommon for what would be perceived as infill development to have wildlife habitat, such as a tree in your example. And often those types of habitat are very valuable for some species, even which are protected under federal law, such as raptors, who may nest in that tree. And so the intent of this interpretation is simply to offer the Department of Wildlife opportunity to review where there could potentially be wildlife impacts. And that is all the intent is that review. Some examples, most notably of late, in Elko, the 7th Street Ponds, surrounded by development as well as surface infrastructure that includes surface transportation for roads as well as railroad tracks. It's right along the river, but it's also surrounded by apartment complexes. And that's an area that is heavily utilized unofficially by folks who want to go down to the river and fish. It also has some trees, willows, other nesting type habitat, but could be perceived as infill development. However, the Department of Wildlife wanted to make accommodation to be able to review those types of areas and provide meaningful feedback to developers on how they might avoid or minimize impacts to wildlife should they go through and try to develop a parcel such as that. I will add in that particular case that parcel will not be developed. It was recently purchased for the recreational use. But the intent is to capture areas such as those that may still have valuable wildlife habitat or may have habitat that is suitable for protected species.
Chair, may I follow up?
Yes, please, go ahead.
So I appreciate that answer. I think, and I get where you're coming from. However, I'm coming at it from more of a policy perspective that we're talking about the planning and zoning chapters and dealing with developments. And I think the appropriate interpretation of vacant or substantially vacant has to do with development of the land, not the habitat on it. And so I am not in favor of passing these regs.
If I may add, there are no current definitions for substantially vacant or infill development within statute currently, which is why we offered interpretation simply for the review by the Department of Wildlife. Those interpretations would not apply to any other review.
I hear where you're coming from, but we're talking about the planning and development statutes on what the counties or cities are doing, and the Department of Wildlife is then inserting in their regulations under the planning and zoning chapter their definition rather than a definition of vacant or substantially vacant that relates to planning and zoning activities. you're coming at it from a wildlife perspective. And I just think it's inconsistent.
Any additional questions at this time, Assemblyman?
No, I don't have any here. Thank you.
Okay. And I see your hand, Senator Hansen. We're going to go with Senator Daly, and then we'll come to you.
Thank you, Madam Chair. And along those lines, my question was in Section 7, where you get to put in written comments on the tentative maps and subdivisions and various things. And not dissimilar, following up on the Assemblyman's questions, you have EIS statements, environmental impacts, various things. This is just a state level. So my question really was, how much weight is given to that? Are they requirements that or things that require mitigation? So what level of oversight or whatever are your recommendations required to be followed, or just recommendations? And just for the record, rock outcropping on vacant land could be habitat for several species, depending on altitude, endangered species. So.
Yes, Jasmine Kleiber again for the record. The intent in Section 7 is really just to provide recommendations. We have no authority over whether any type of subdivision or development would in fact be authorized or not. We're simply trying to provide feedback to developers as well as those who are responsible for authorizing those types of developments to understand whether it might be suitable to leave additional open space or to avoid or minimize specific areas that are highly valuable to wildlife species. But our recommendations are just that. There is no obligation to follow mitigation or to accept it, nor is there any obligation or requirement to implement or otherwise have a developer adhere to management practices or other avoidance measures. They're just recommendations.
Understood, and that's what I wanted to try to find out. It seems like a lot of work to go through that. But it might be helpful to other, like if they do have to do an environmental impact statement, your findings, recommendations could be taken into consideration by other people. And I'm not anti-development. I think people know that. But at the same time, there needs to be a balance. So I'm glad that you're going to be able to have some oversight and be able to make those recommendations. I find a lot of times the planning agencies and the government agencies would value that as much as you guys are giving it. So that was all my questions, Madam Chair. Thank you.
And if I may add to that, the Department of Wildlife currently has a review program that provides these types of recommendations and review of projects across public lands. And on average, we review about 600 projects a year on public lands. So we're very familiar with the process. It would simply be adding that to subdivision development.
Okay, thank you. We will go to Senator Hansen.
Thanks, Madam Chair. When I was reviewing the reg on this, I saw a cost of $1,400 for an average review by you guys. Is that number accurate? One of the big concerns we have is rising costs of housing, and if every time you guys review one of these, the average increase in the cost of the house is $1,400, I think that's a legitimate concern.
Yeah, so Jasmine Kleiber for the record. That value was brought up during the small business impact analyses. We've currently had, since the implementation or the passage of Assembly Bill 211 during 2021 legislative session, we've had approximately 52 different projects or developers submit maps to us for review. And the average for review has worked out to be approximately $810 per subdivision. And we don't anticipate that to fluctuate a tremendous amount, although we would expect it to change when we're having periods of increased development activity or decreased development activity. And so I will add that we're looking at less than $1,000 per subdivision, not per lot or per house. It would be per development.
Okay, and along those same lines, how do you guys determine which properties you are going to review and which ones you are not? Does somebody have to make the request to you guys, or do you make the determination internally?
No, the requirement to submit to the Department of Wildlife is entirely based off of existing statute and regulations to when a developer has to submit a tentative map to a planning body, commission, or other authorizing entity. That's the trigger that then causes the Department of Wildlife to be included in review of those maps. We don't make any determination at the department.
Well, you did mention habitat. Any habitat, you have a tree on a lot. Senator Daley mentioned a rock outcropping, even bare ground. I mean, you can see all sorts of things, especially in Nevada on bare ground. I'm just kind of wondering what is the trigger on the habitat side of it for you guys?
Yeah, the habitat side is really specific toward actual native vegetation. That was the intent. Rock outcrops are fantastic habitat for some species, but are not often the areas where a developer is going to raise and put a housing development. Often the topography is not quite suitable. It can be, but typically what happens is developers will come to us early on to begin with and ask for recommendations or feedback, and so we can help guide through the process initially prior to a formal map being submitted. However, once the formal map is submitted, the tentative map is submitted to the governing body, that's when we take a look at the map and take a look at what habitat resources may be there or wildlife resources may be there. And if there are none, then it's not warranted to continue review.
Okay, last question along those same lines. When somebody does make the request to you guys, is there any other agencies that are kind of duplicating the same effort? We mentioned, EPA or various other things that could possibly trigger a concern. What I'm wondering is, are we getting a redundant review of wildlife and habitat by having NDOW do it rather than the other agencies that have apparently been doing it prior to at least 2021?
Yeah, there are numerous other agencies that currently already conduct subdivision review, but generally the intent of their review are for other purposes such as effluent, wastewater, and so not specific to wildlife. Also, none of the other agencies currently have management authority over wildlife or expertise in it, and I think the intent was to include wildlife for a more comprehensive, a more robust review.
Very good. Thank you, Madam Chair.
Thank you. Any additional questions from members of the commission? Not seeing or hearing any. Senator Daley.
Madam Chair, I would move to approve Regulation R 162-22.
I do have a motion to approve from Senator Daley. I have a second from Assemblywoman Bacchus. Is there any discussion on that motion? Hearing and seeing none, all those in favor, please signify by saying aye.
Aye.
Aye. And any opposed? Say
No.
Nay.
Nay.
Nay. Nay.
Okay, I think I have nays from Senator Stone, Senator Hansen, Assemblywoman Hansen, and Senator Krasner. Is that correct? Yep, and Assemblyman DeLong. Okay, with that, the motion does carry. R 162-22 will be adopted. And we will move on to our next regulation, R 199-22 for the Real Estate Commission. And we've got someone here in Vegas who will come up and get situated. And then Senator Daley, when you are ready, I'll turn it over to you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Sharath Chandra, Administrator for the Real Estate Division here. Thank you.
Thank you, Madam Chair. And I know probably some comments as well, but if we can ask for the commission, when you develop regulations, do you believe the commission's required to follow NRS and that their regulations have to comport with the NRS and not run opposite or violate the NRS? So you're required to follow NRS when you're submitting your regulations?
That is correct, sir. Sharath Chandra, Administrator for the Real Estate Division.
Right, and so I'm trying to figure out when you go to section 8, and it says the provisions of NRS 645.060 do not prohibit a member of the commission who has served for a period of 6 years consecutively from continuing to serve until his or her successor has been appointed and qualified, which is exactly opposite of what the statute says. It says a person cannot serve more than 6 years. In fact, it has an exemption. If someone was appointed to fill a vacancy, or not a vacancy, but to fill an unfilled term of less than 18 months, then they can go past the 6 years, but for no other reason. So if this language is in direct violation of the statute, how can you expect it to be passed by this? Because it exceeds your authority. Part of what we're supposed to do is review to see if you're within the authority that you've been granted for your statuations, but this is clearly in violation of the statute.
Shrat Chandra, Administrator for the Real Estate Division. Thank you for that question. So essentially, the intent here was based on language that is in 232A.020, which is basically talks about the terms. And I think the genesis of this is there is no language in our statute that specifically talks about what happens when there's a gap between when a governor appoints the next member and there's a body that doesn't have a quorum or those kind of situations. And we've come across some of those situations where the governor appointment is still, being done, and then there's a serving member on the board that we believe should continue till the new appointment is done. And so we looked at 232A.020 for actually the language, and this was one of the questions that we posed to the LCB folks when we were drafting this is what we want to do. We want to make sure that we are in alignment with the 232A, but there is a gap in 645 that talks to that little portion. And so the language was basically proposed by LCB to make sure that we don't go against the 645 language, but also stay within the statutory requirements under 232A to make sure that we address that gap. And that was all we were trying to do.
And I understand, and I served this last interim on the Sunset Subcommittee, and we reviewed lots of boards that had vacancies and unfilled positions and haven't met in years and various things. So that's not an uncommon thing. But your specific statute clearly states, and it's unambiguous, cannot serve more than 6 years consecutively. You can be reappointed after a 3-year gap, specifically. And the plain language of the law on a specific point always overrules or trumps or whatever, what words you want to use. The specific always has more precedent than the general application broad. And I understand LCB may want to try to help you get to where you're going, but it still conflicts with the law as written, plain language. In fact, if you have those words and you go forward with this, I think it would allow potentially to say, hey, we've got a guy we want, he's doing what we want. Whoever's appointing, whether it's the governor or somebody else, could say, nope, this is my guy. I'm just not going to appoint someone else because that helps me have control on this board. There are reasons that this language was put in there. Bills get passed by the legislature and people scrutinize, at least I do, over every single word that gets put in. There was a reason the 6-year limitation was put in. I says, and I don't believe that you can override it by regulation, no matter how much you want to. And the standards of judicial review, we don't get to decide. But Legislative Commission has to look and see if you're within the confines of your statute, if you're exceeding your authority, and clearly this is regardless. And I understand LCB may have their opinion, but if this went in, it would eliminate the plain language of the law, which to me would be an absurd conclusion if you were looking at judicial review. You can't give or render those words meaningless through a regulation. 'Cause
Sharat Chandra, Administrator for the Real Estate Division. Thank you for those comments. Again, I think we are in that situation where there is language in 233A which allows for that. And so, again, we rely on counsel and LCB. We're not attorneys. And so that's basically how we got to this point. And so I understand your concerns, and hopefully someone else can address those beyond the scope of my
I just don't think the Legislative Commission be doing our job if we did that. Before we get from council, I have a second question, and that was in section 23, subsection 6, where you're requesting or wanting to put in there that you're going to publish a manual. So what type of information is going to be in this manual that how are you interpreting what's going to be in the manual and how that applies and who that applies to?
Sharat Chandra, Administrator for the Real Estate Division. So essentially, this is a manual that we propose to do for the education section. As you're aware, there's a emphasis on continuing education for real estate practitioners, and so they're required to do 36 hours of continuing education. Some of them are in specific areas, and so the regulation generally talks about those areas, but the manual kind of helps either the sponsor or the educator and the person taking the courses to understand what the requirements of those. The division doesn't develop courses. What we do is we look to the industry for expertise to develop courses, and that way we're not controlling the content. What we just do is we do an overview of what is required to meet those constraints of that course. And so essentially the guide gives a little more clarity on specifics of how that course needs to be structured, or generally things that are not, without going into the minutiae in a regulation, we want to do that in a guidebook that just basically kind of outlines the process of how someone would submit for an education course and some information on it. That's the intent of the course, the guidebook.
Yeah, and thank you for that. And what I was trying to get to on that particular thing is how far are we going, and who it applies to, and if it's going to be rules of general application to the public, or is it more narrow onto providers and various things, more internal? Because you don't want to go past and create regulation in your manual and end up with the challenge there. So that part of it I'm okay, but I disagree with the other part of it. I think it clearly goes against the statute, whether you want it that way or not, and I wouldn't be able to support the regulation with that provision in there. So those were my two questions, Madam Chair. Thank you.
Great, thank you. Any other questions from members of the commission?
Yes, Chair.
Senator Hansen, please go ahead. We'll go Senator Hansen, then we'll come to you.
Thank you.
Thanks, Madam Chair. No, I just wanted to find out if legal was going to chime in on this. I thought they were going to give their 2 cents worth, because if Senator Daley's concerns are correct, then this should be remanded back to the agency.
And I believe that we do have some guidance from our legal counsel on this. So I'll let them kind of chime in, and then I think maybe we can have an ongoing discussion with members of the commission. I know I have Assemblyman DeLong may have another, maybe a separate question, but I'll turn it over to Mr. Killian.
Thank you, Madam Chair. Asher Killian, Legislative Counsel. So our reading of the provisions of Section 8 are not that this provision is intended to overrule existing law, but rather to recognize a principle of statutory construction, which is that when there are two statutes that are amenable to multiple readings, some of which would create a conflict and some of which could be read harmoniously with each other. The courts generally prefer to find readings of those sections that can be read harmoniously with each other and give effect to both provisions of law rather than finding a conflict that would require one of the provisions of law to be overruled. In this case, NRS 645-060 is a statute that governs appointments to the Real Estate Commission, and it sets a term limit of 6 years for the purpose of appointment. NRS 232A-020 is a general law for appointments by the governor to boards and commissions that set the term length to 3 years unless otherwise specified and allow members to continue serving until their successor is appointed and qualified in order to avoid situations where, perhaps due to term limits, there are no eligible persons to serve on a body, and as a result, the body may not have a quorum and may not be able to take action. It's our office's opinion that the intent of Section 8 is to recognize these two provisions and read them harmoniously in a way that prohibits a person from being appointed to another term if they have served 6 years, to give meaning to NRS 645-060, but to also give meaning to NRS 232-020 by, in a situation where a person who is otherwise term limited, but no other person has been appointed and qualified, that person may continue to serve until such a person is appointed and qualified. So that no vacancy is created that may prohibit the Real Estate Commission from operating. Ultimately, it's the job of the Legislative Commission to determine what legislative intent is. So the question is before this body as to whether the intent of the legislature is for these two provisions to be read together harmoniously, or if the intent of the legislature was that there be a conflict, and that members who have been term limited are not only prohibited from being reappointed, but also immediately removed from office upon hitting that mark and cannot continue to serve until their successor is appointed and qualified. So ultimately, the question is for this body as to what the legislature's intent was, but we believe there is a legal justification for either intent depending on what the Legislative Commission decides.
Senator Hansen, I don't know if that prompted any questions from you.
Well, thank you, Madam Chair. I actually didn't do the level of scrutiny that Senator Daly did, so I'm going to, frankly, if Senator Daly's okay with the reg, I'll vote for it. If Senator Daly thinks that this conflict is significant enough that we need to send it back to get that clarification in the regulation, I will vote no. So I'm kind of leaving it in a skip's lap. Thanks, Madam Chair.
Thank you, Senator. Assemblyman DeLong, if you have additional questions, we'll go to you next.
Thank you, Chair. No, that Asher answered my questions. Thank you.
Okay, great. Senator Daly, I think you had a question, and then I see Assemblywoman Hansen.
I did. I just wanted to follow up, and I think I understand trying to get both of those to mesh, et cetera. But the specific law is going to override or take precedence, if you will, and be applied before the more general law regarding appointments of boards. And in this one specifically, the language in 645 says members are eligible for reappointment, but shall not serve for a period greater than 6 years consecutively, after which time they may be eligible for appointment or reappointment, or not eligible until 3 years have elapsed. And then it goes on to say that there's a provision where if they are filling an unexpired term, that they can be over the 6 years if it's less than 18 months. There's no provision about, filling the board until someone else's term, and I'm sure that, or someone else is qualified, and there's that general language. But if you're going to try to override and say, hey, the specific is supposed to be complementary to this, I just don't see it. And every time I've, had an arbitration or a court case or whatever, the standards of judicial review have always favored first, the plain language of the law. If it's unambiguous, you can't serve more than 6 years, you can't serve more than 6 years. right? And the governor has a responsibility to appoint. There's a remedy for people for that. If the governor doesn't appoint, you can do a writ of mandamus. So there are other remedies to resolve this rather than trying to adopt two laws that allows a person to go against the plain language of the law. Can't support it. It's just flat out against the rule, the way I read it. And the plain language is right there in front of us. And even Mr. Asher said the specific rule says this, but we're going to try to take a general rule and comport it. So I disagree. So.
Thank you, Senator. We'll go to Assemblywoman Hanson next.
Thank you, Chair. Boy, I really like this regulation, but this section that's been brought up, and I appreciate legals jumping on and helping clarify for us. But to me, I'm seeing that whether we see it's in harmony or it's in conflict, the point that was just brought up, one statute says a 3-year, one says a 6-year. I'm seeing this as in conflict, although I love all the other sections. I think it's really a helpful and needed regulation. So unfortunately, I think I would have to vote that we remand it back just to see if can we bring this reg again without maybe, is it that vital we have this section in there? We have a very robust realtor community and real estate professionals. I'm not understanding why there would be such difficulty and have a gap in an appointment to have this kind of remedy. So it was a comment, not a question.
No, that's totally fine, Assemblywoman. I think I'm generally getting from the tenor of the commission that there is a significant concern, and while certainly you can read both of those statutes to allow for there to be a holdover appointee, I think that is in the context where someone is looking to get appointed. It may be a holdover for a few weeks or so. But certainly as written, there is the possibility and the opportunity for someone who has well exceeded that term limited amount of time in the absence of an appointment to simply hold over for a period of years, which would be well outside of what I think the intent is of either of those statutes. And so I certainly understand, and I think the commission understands the desire for there to not be a lack of members on the commission so that you can continue to do your business, which I know is a concern for many boards and commissions that we have. But I do think that there maybe needs to be some cleanup in the language of this particular regulation such that we can make sure that you all are operating, but that we also have some confidence that this could not be abused by someone who may wish to, extend their stay longer than really is intended by the statute. As the members of the Legislative Commission and those of you with us here today know, we as a Legislative Commission cannot amend or change a regulation that is before us. We can merely adopt it as it is presented to us, but we do have the option of asking for the agency without a vote of this commission to go back and try to rework some of that language and figure out if there maybe is a way for you to work that out or simply to just understand that, you may be in a position where unfortunately you don't have someone filling that commission and may have to make sure that you're working amongst your colleagues, as Assemblywoman Hanson pointed out, to get someone who is qualified and willing to sit on those boards and commissions, which I acknowledge can sometimes be much more difficult than we imagine to ask folks out of their busy schedules to come and sit on boards and commissions. But somehow I think we've managed to do that with a great number of them. So I think at this point, will defer this regulation, send it back to the commission with the understanding that, that's where I think this commission has some significant concerns. And we'll look forward to seeing a new regulation from you at the end of your process that hopefully addresses that.
Thank you, Madam Chair.
No, thank you so much for being here with us today. Members of the commission, that will bring us to our next regulation on the agenda, which is R025-23 for the Division of Industrial Relations, Department of Business and Industry. I have some folks here in Las Vegas where we're going to let get settled. And then I will go first to you, Senator Daley, and then we will go to Senator Stone. So Senator Daley, whenever you're ready.
Thank you, Madam Chair. Is the person down south?
Yes, we have them here.
They are. There they are. There they are. Just a couple of clarifying questions. So in, I believe it's section 1, subsection 2, I might have that written down wrong. Regarding the maintenance control program, you guys are eliminating the fee for turning that report in. So is the report still required? There's just no fee?
Victoria Carrion for the record. I'm the administrator of the Division of Industrial Relations. So that fee and that program is no longer required. So that's why we are recommending to repeal that portion of the regulation.
So the maintenance control program report is also defunct and it's covered somewhere else, what you have to do. So no fee, no report either.
Brennan Patterson, Division of Industrial Relations Chief in the Mechanical Section. I think to clarify that, the fee is not required for filing of the maintenance control program, but maintenance control programs are still a requirement for every elevator, both under the ASME codes we adopt by reference and generally within the NAC.
Okay, and I just wanted to be clear. I mean, we can get rid of the fee, but the report is still there. A lot of moving parts on an elevator. A lot of things can go wrong. People need to have confidence in that. So my second question, if I can, Madam Chair, was in Section 3, where one of your regulations you're eliminating, which is 455C-503, where if an elevator travels 55 feet or less, they don't have to have, what was the term? Whatever it was that had the phase 2 control from inside the car. So now all elevators are going to have that control by eliminating that regulation, or how is that interpreting going to be administered?
Victoria Carrion for the record. So that provision is no longer required, but Brennan Patterson will provide a little bit more information.
Brennan Patterson for the record. The provision was an old exemption at a time when the technology for phase 1 and phase 2 emergency recall and control of elevators was just coming online. We did a review of all of the permits we've issued for elevators in the past decade or more. There are no current elevators being proposed to be built that don't have phase 2 functionality. It's standard equipment with elevators, so the provision appeared to be unnecessary.
And thank you for that. That's all I was just wanting to make sure. It seemed to me that you see that on the panels. I don't know everything that some of that stuff does for the firefighters and everybody else, but it seems to me it would be a useful deal regardless of the distance that you would be traveling. So thank you for that. Those were my only two questions, and I'll make a motion whenever you're ready, Madam Chair.
Okay, I believe we do have some questions from Senator Stone, so we will go to Senator Stone, and you can proceed when ready.
Thank you, Madam Chair, and thank you for being here. Again, reading notes, companies have shared some concerns about the cost and ultimately the delays in the elevator operability. We know that throughout Nevada and throughout the country, office space is struggling. And there could be enormous costs with the modernization of older elevators, which in many cases have never had any issues in the years in the past. I was just wondering, is there any grandfathering? And listen, I don't want to do anything that's going to jeopardize the safety of anybody using an elevator, but we have some older elevators that have never had an issue. They've been regularly inspected. Of course, there's new process boards that make elevators work a lot differently and a lot more efficiently and safer. But how do we address some of the concerns of some of these smaller buildings, if you will, or even larger buildings that have these older elevators that be functioning fine, but to go into retrofit them, not only is expensive, but it's also going to leave those elevators inoperable for some time. Has there been some mitigating language, or have you been able to appease some of the entities that have been concerned about the delays and costs?
Victoria Carrion for the record, Administrator, Division of Industrial Relations. So in terms of retrofit of elevators, that is not one of the provisions that's part of this particular regulation. So that's beyond the scope of what we're proposing today. But in answer to the question, I know there are certain provisions that require all elevators to meet certain basic safety requirements, and that is part of the existing elevator code. In a previous regulation that was adopted, that we provided additional time to meet some of those provisions. There were some specific things, including door lock monitoring, ascending car overspeed protection, and what's the other one? Door restrictors. Those three things, we had received feedback that those were sometimes costly to implement, and so additional time was written into the regulation to achieve compliance with those provisions. So that has previously been addressed, Senator. Thank you.
I appreciate it. Could you just tell me what kind of extension of time has been offered to the quasi opponents, if you will, and were they satisfied with that extension of time?
Brendan Patterson for the record, Division of Industrial Relations. Under R3421, which was adopted in August of 2023, the provisions for door lock monitoring and door restrictors, those requirements on older existing elevators were pushed to December 31st, 2025, and the requirement for ascending car overspeed protection provisions was pushed to December 31st, 2027.
That's great. Thank you very much.
Additional questions from members of the commission? Okay, I am not seeing any. Senator Daley, I believe you had a motion.
Thank you, Madam Chair. Yes, I would move to approve R025-23.
Okay, I have a motion to approve. I have a second from Assemblywoman Backus. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Any opposed, say nay. Hearing none, motion carries unanimously. R025-23 will be adopted. Thank you all so much. Our next regulation is R081-23 from the State Treasurer. And I believe that Senator Daley, you had some questions, so I will turn it over to you once we get folks settled up there in Carson City.
Thank you, Madam Chair, and I think it's an easy one. It's not going to be too hard. No, my question was in Section 5, where we're talking about the language for underserved communities, various things. You're going to rely on some data that's available out there. And what I wanted to try to get on the record, just so the Legislative Commission understands how it's going to be interpreted and actually applied, and give some guidance to future people in the Treasurer's office to give some guidance there as well. So how are you going to measure that? I know in some of the other criteria, as you say, there are thresholds, there's minimums. On this, there wasn't really any, and I don't know enough about the data or how you're doing it to be able to make a judgment. So I was just looking for clarification on there's going to be a scale that is going to be in the data, and if a person who wants their loans repaid is going to an area with higher versus lower, or is it all going to be looked at equally? That's what I just want to try to have as a little idea of how it's going to be applied, to try to give some direction to us as we approve it, and future direction. So hopefully that's continued to be administered if we're satisfied with your answer.
Thank you for the question, Senator Daly. Eric Jimenez with the Treasurer's Office for the record. And I do my best to try to satisfy you with every one of my answers. Sometimes I succeed, sometimes I don't. But this is a great question, Senator, and something we've been really wrapping our head around. I'll point your attention to both Section 4 and Section 5 of the regulation. So this is all to implement Assembly Bill 45 from the last legislative session. I don't expect you to have Assembly Bill 45 in front of you, but that essentially made sure that any provider that wanted to participate in this loan repayment program had to be either ready to relocate or currently practicing in a number of different communities. Some of those are very clearly defined, whether you're in a low-income census tract, whether you're in an area that has a high social vulnerability index from the Centers for Disease Control. They have an index that measures these things. There's a percentage for certain census tracts that are high areas without English proficiency. I think it's 20% of households that are not English language proficient. Tribal communities and rural communities. And then there is one section, and this is where you'll see in Section 5, which is areas that have been historically subjected to things like discrimination, redlining, and other discriminatory practices. As we kind of worked through the legislative process, we realized that wasn't defined anywhere, and it's really hard to I think, track down some of that data. Most of the conversations that we had with stakeholders, well, you go to that community, you know it when you see it, right? And while I agree that you probably know it when you see it, I think it's also important that we measure those things. So then we started working with LCB and Brian Burnley with LCB, who was incredibly helpful for this, and said, how can we figure out certain factors to measure discrimination and redlining and things like that? One is, and we've come on the 3 areas in Section 5. One is whether or not they have a high level of residential segregation. Number 2 is disparities within educational attainment and household income based on the factors that are in Assembly Bill 45. So things like race, gender, disability status, other things like that. And those are the things that we will measure. Now, I agree with you that I think it is this office's, and I think the legislature's intent to set some benchmark metrics so we're not making kind of just ad hoc decisions. And I think the Treasurer's Office is more than willing to put out documents before we launch this program to make sure that we're clearly saying what those thresholds should be for all of those. So I hope that was satisfactory.
Yes, and I think so. I just wanted to have something on the record to that level, because the data is not there. There are certain things you can look at, but it's also some historical factors and various things. They don't do redlining anymore, at least not officially, right? So you got some historical areas to look at. My question was really more in degree. So how much of it has been mitigated? How much of it is this area moving? I'm hoping that you have more applicants for this than you have money, so you have to make some of these decisions. I know that if you have more money than you have applicants, you open the enrollment period. I did read that. I hope that's not going to be the case. But then when you're looking at that is, if a person's in one area versus another, how are you going to measure that? And those benchmarks are not listed in here. And I know that may be a difficult thing. And that's all I was looking for, was to say, if we have a higher percentage of all one race, and there's historical documents that they're concentrated in that area based on previous segregation and discrimination, whatever it might have been. If someone's relocating to that, they're going to score higher than if an area that's got 5% or not as much historical information there. That's what I was looking for, is that there's going to be a rating system and points at some point if there's competing people.
And again, Eric Jimenez for the record. And Senator, I am so glad you asked that question, because in Section 10, you'll see the framework for a scoring rubric that takes into account a number of different factors. We went through a large kind of discussion throughout the robust regulatory process that we had. We had 2 workshops on this. I think everybody at those workshops felt heard and really kind of got on the same page. We felt it was best to go through a scoring rubric that measured different metrics. You can see those outlined in Section 10, but also that this scoring rubric, as we get more data for the program, could also be kind of move over time. So if we're seeing certain types of provider types that we really need, that we could score those types of provider types higher. If we're seeing certain geographic communities that need those types of or certain types of providers, those could be scored higher. Or if we're seeing, I think one of the factors that we're thinking in our rubric is also language access. So for example, if you're in an urban community and they have a high Vietnamese population, and we're really struggling to get doctors that speak Vietnamese, like how can that applicant be scored higher, kind of moving through this program since this is a longer term program. So I think what we've done is created a metric where everyone will be on the same page. It'll be a publicly available rubric before the application process, but then that rubric can also move over time to kind of meet the needs of the communities across the state.
And thank you. I did see the rubric. I just was wanting to make sure that something like that was going to be applied to Section 5. And I didn't see it directly, but maybe I just missed it. But yeah, no, that satisfies my answer. I just wanted to make sure that the data is not as established as some of the other stuff, is not as clear cut, and that proper weighting was going to be given if there were competing applicants for that particular section of it. So that all of my questions, Madam Chair. I just wanted to get that on the record and give guidance both to us and to the office on how they're going to interpret that. Thank you.
Thank you, Senator. Any other questions from members of the commission?
Yes, Chair, I have a question.
Please go ahead.
Thank you. Appreciate you being here in person. I think that's great. You had just mentioned in responding to Senator Daley's queries about coming up with metrics prior to implementing the program. For me, that implies you're looking at doing that through policy. Am I correct with that?
I guess if you could, Eric Jimenez, for the record, if you could just specify that. I think some things are kind of like the application process and what metrics will be scored or will be done in regulation, but the actual scoring kind of criteria is set forth in the regulation and would be done by the agency.
But I thought you were talking about actually setting thresholds for each of those. Would that be done by policy or regulation?
That would be done by policy.
Okay, so when you do that, then setting those threshold values, if you do it by policy, there's no public input process. And I have a problem with that, so.
Yeah, and I would wholeheartedly disagree with you, Assemblyman, that there would be no public input process. We have gone through a robust public engagement process. This bill is the result of a statewide listening tour that consisted of 123 events over 87 days with the last governor and across communities all over the state. We did 90 days of listening before we did the regulatory process. We did 2 workshops and a public hearing, and we are continuing to get feedback from something like 50 or 60 groups before each of these documents go live. So, like, I hear you from a kind of like a practice standpoint, but this office is just not going to not take in public input.
I appreciate that. That's not where I'm going, and I'm not questioning what you've done. I'm questioning about what's going to happen in the future. And if by doing it through policy, you don't have that formal propose a regulation, go through public workshops, bring that regulation in front of the commission. Does the commission think it's appropriate? That's what I'm questioning. So it's just food for thought at this point. I have nothing else, Chair.
Yep, no, thank you. Any additional questions or comments from members of the commission? Okay, I'm seeing none. Senator Daley.
Thank you, Madam Chair. I would move to approve.
Do you have a motion?
Move to approve.
I do have a motion. Go ahead.
R081-23.
All right, I do have a motion to approve from Senator Daley. I have a second from Assemblywoman Backus. Any discussion on the motion? Hearing none. All those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Any opposed, say nay. I am hearing no nays. Motion carries unanimously. R081-23 will be approved. We will go to our next regulation on our list. It's R097-23 from the Commissioner of Financial Institutions. And they are going to get settled here in Las Vegas. Senator Daley will let you go ahead and begin when you are ready once they've taken their chairs. Give them just a minute.
Good afternoon. Sandy O'Loughlin, Commissioner of Financial Institutions Division, and with me is Mary Young, Deputy Commissioner, Financial Institutions.
Yeah, thank you. And my question, just on one of the repealed sections, and I know we had the whole exercise, and some good repeals have been done and other things, and I think the repeal of the section 649.086 is a redundant section that should be repealed. But I did just have a question on that where the language said, hey, we're specifically making these things public. Those things were already public. There's already language in 239 that says just because somebody made something public doesn't mean that other records have to be stated as being public. They're still already public, regardless of language like that. So it's not needed. The real clarification that I was looking for was, does the commissioner, whoever the authority is, believe that there's some authority for them to be able to make things confidential that are not already confidential? Or how's that process going to work?
Mary Young, Financial Institutions Division, for the record. SB 276 added a lot of additional confidentiality provisions to Chapter 649 to cover what is confidential. So if we were to get a public records request, we would have to follow, of course, the public records law as well as what's in SB 276 and 649.
And thank you. And that's just what I wanted to make sure was clear on the record, is that if something has been made confidential by statute, then you've got your test there on what it is. If it's not declared confidential, then it's public, and that's just been the black and the white of it. Some people may object to whatever, but that's the way it stands right now. I just wanted that clarification was all. I think getting rid of that eliminates confusion. And if you have other records say this is what's confidential and then it's been passed by the legislature, I'm satisfied with that. Just want to make sure we're not extending anywhere past that. That was my question, Madam Chair.
Okay. Any additional questions or comments from members of the commission? I am not seeing any. Do you have a motion, Senator?
Yes, Madam Chair, I move to approve R 097-23.
Great. I do have a motion to approve from Senator Daley. I have a second from Assemblywoman Backus. Is there any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Any opposed, say nay. Hearing none, motion carries unanimously. Thank you so much for being here with us. R 097-23 will be adopted by the commission. The next item on our list is R 136-23 for the Commission on Ethics. And I will start with Assemblywoman Anderson, when you are ready and once they've gotten a chance to get settled there in Carson City, we'll turn it over to you. And then I've got Senator Daley up after you.
Thank you, Chair, and thank you for being here today. My questions, I've got a few of them. The first question I've got has to do with Section 5, I believe. Let me see if I can find my little questions. That The first area that's being crossed out would take away the written communication or document filed with the commission, which it appears would be the complaint. But then later, it refers to NRS 281A.500, which has also to do with some written documentation, but that's actually the acknowledgement that's sent to each elected official. So I'm confused. Are you getting rid of a document needing to be actually filed if there is in fact an ethics complaint against an elected official? I'm really confused with this strikeout language and what exactly the intent is.
Thank you for the question. Ross Armstrong, Executive Director of the Nevada Commission on Ethics. When we looked at our regulations to see if there were ways that we could streamline it, we found that this was kind of an old-fashioned way of describing how writings needed to be filed. There's another part of the regulation that changes it from being filed at the office to just filed with the commission because we can receive an email. So the strike-through language is really just allowing all different types of written communication to come into the commission for consideration instead of putting those restrictions on it.
Thank you for that clarification. I thought that's what it was, because then later in section 11, there's another reference to written documentation, I believe. But I'm concerned about the beginning part of section 11. I think this is a little bit more of a concern for me. Under section 11, with the anonymous complaint automatically being rejected, but then later in section 11, there continues to be information where identity is confidential, and that is not being looked at. And I think it's very important that we continue to protect our whistleblowers. So I'm just curious how exactly that is described in this regulation change, and or how you see the protection of our whistleblowers being protected in this change of the regulation.
Thank you for that question. I think to really understand Section 11 of these regulations, it's important to know the part of our statutory framework. So in the statute, in the Nevada Revised Statutes, we are prohibited from receiving anonymous complaints. But sort of the cumbersome procedural way we go about that now is if we receive an anonymous complaint or they haven't identified anybody, then the Commission Council and I spend time creating a jurisdictional recommendation and go through the process of submitting that to the Commission. The Commissioners vote and say, okay, yes, this is an anonymous complaint. Those aren't allowed. We don't have jurisdiction. And so in order to be more efficient, those that are received the anonymous, or if they haven't identified someone, those would just get rejected and not have to go to the full commission in order to have that jurisdictional determination, because it's our interpretation that that's not a legal complaint that has been filed. In terms of the protection of whistleblowers, the ethics statute says that there are two reasons that somebody who files a complaint, because I said it can't be anonymous, but there are certain instances when confidential protections apply to the requester. And that is if the requester works at the same agency as the person they're filing the complaint about, or the individual includes in the complaint sufficient information that there is a substantial threat of physical force or bodily harm to them or their family members if their identity is discovered. Those are the only two ways that the identity of the requester is held confidential by the Commission.
So if I may have a follow-up, Chair, if I may. And I will 100% admit this, I have not studied as deeply as my good colleague over here, Senator Daley, the NRS statutes as I should have to prepare for today. When it comes, though, to a possible anonymous complaint, the name is given. The Commission gets to make the decision whether or not the name is actually released. And the only two areas that decision is based upon is if there's any possibility of bodily harm or if they're in the same department. Is that correct? And if so, that is another concern that's possibly a discussion for another day.
Thank you, Assemblywoman. So I want to make sure I get your question right. If there's an anonymous complaint filed, we can't take, it can be the most serious, perfect ethics violation that's ever come through our door. If it's filed by an anonymous person, we cannot take jurisdiction. That's our statutory restriction. But those two those two requirements about when we would hold something confidential are also established in statute.
Thank you so much. And then my last question has to do with the decision to remove, let me see if I can find this section. It's towards the end. I can remember that. The decision to, on section 16.1A, the written notice of the hearing in matter which must not be held not later than 60 days. Why that decision is made when already the subject can actually make the decision to waive the time limit. So just wondering why that is now being striked out as well.
Thank you for the question. Was we went through the regulation review. That language is exactly what's in the statute for the timeframes, and so it was just removing that from regulation because it's already required by statute.
Thank you so much for that clarification, and thank you, Chair. I still do have concerns about some of the other information I believe will be brought up from others. Thank you, Chair.
All right, I believe we have questions next from Senator Daley.
Thank you, Madam Vice Chair. So, question before I get to the section and various things. So, who under your statute can ask for an advisory opinion? Anybody, or only who can ask for an advisory opinion?
Thank you. I will defer to our Commission Counsel Liz Bassett, who handles our advisory opinion process, to help answer that.
Thank you, Senator. Elizabeth Bassett for the record. Currently, as our statutes are written, the only people who can ask for an advisory opinion are a public officer or a public employee who are currently employed or appointed.
Okay, under the current deal. And then that gets to my question in section 2, where you're changing the definition of a subject from a public officer or public employee. So is that in statute where only the public officer or public employee can ask for an opinion?
Thank you, Senator Daley. This is Executive Director Armstrong. So subject is a term we use when we're talking about ethics complaints. And so we worked with the LCB to remove public officer or public employee because there's later parts in the regulations where it talks about a subject of a complaint is do certain things. But if they're not a public officer or public employee, people file ethics complaints against non-public officers and employees regularly. And so this just makes it clear that the subject is whoever is the person that is the subject of the complaint. It still can't be an entity. You can't file ethics complaint against like an entire county commission, but it is any person, whether they be a private or public official, can be the subject of a complaint, but we'll never take jurisdiction over a complaint unless they're a public officer or employee or a former public officer or employee in certain circumstances.
And that just gets to my point. So people, because they don't understand and they don't know, can file a complaint against the contractor. It's an ethics complaint, but you guys don't have jurisdiction over that private enterprise. Go to the contractor's board or go to whoever it is. I have a ethics complaint against an attorney. There's a process for that, but it's not you guys unless they work for the state or the government somewhere, right? And that's where changing the subject to a person, right? And I was looking at your statute just now, actually, and there's no definition of person in your statute, no specific on that, which then defaults to the zero chapter. A lot of people don't know there's a zero chapter, but 0.39 of a person, basically that's everybody, right? Corporations, everybody. So I think it just creates a confusion. I would hope the words could be worked on, because a person, under the definition of 039, you don't have, can't be the subject in most cases, right? And that's why I just think that I have a problem with person being overly broad on who you're talking about and who the subject of a complaint can be, right? And I think when you say, well, the subject means any person, and then people are filing complaints against people you don't have jurisdiction over, you're going to be writing a lot of determinations that we don't have jurisdiction. I just don't think person is the right choice of words there, sorry. I don't know if you have a response or not, but I think that's a problem. It's overly broad.
Yeah, this is Executive Director Armstrong. Again, I think our intent in adjusting that in Section 2 was so that the appropriate process would be followed in terms of receiving in those initial phases of a complaint, whether or not the person was a public officer or employee. That it's just, we can't control who people put on the subject line of the subject of a complaint. And so by allowing it to be person, then that allows us to then appropriately handle it. We're not expanding the scope of the Ethics Commission. We can't do that from the regs, clearly. But for us, when we took a look at Section 2, it just seemed like it was narrow in an unnecessary way.
And you could have referred back to what your statute is on who you have jurisdiction, or the subject means anybody over which we have jurisdiction pursuant to, and then list the statute or the regulation or whatever it might be. I think that would be a better definition, because when you get down further and you're talking about a subject, of course, either after you've determined you have jurisdiction, can make requests, they can make motions through their attorney, they can request subpoenas, various things. And using the person there and then subject later, I just think is going to create confusion. That was all my questions, Madam Chair, Vice Chair, still. Thank you. Oh, no, the chair is back. Thank you.
That's okay. That's okay, Senator. Are there additional questions or comments from members of the commission? I do think, because some of this has been brought up, and so I think one of the questions, especially in regard to Senator Daley, your interpretation and the use of the word person, I'd like to ask Mr. Killian if he can kind of weigh in on that, to give us some context on how that works and what that might mean, and whether we have multiple interpretations here in front of us, or if that seems to be something that maybe could be, I think, at least clarified a little bit. But Mr. Killian, I'll let you sort of take the helm.
Thank you, Madam Chair. Asher Killian, Legislative Counsel. So the core rule that Senator Daley referenced is correct, and that Executive Director Armstrong also referenced. The Commission on Ethics does not have the power by regulation to change the persons who, by law, it has jurisdiction over. And so that would be the fundamental rule that a court would apply in interpreting this regulation, and the change to NAC 281A 100 by this regulation would be to refer back to the law and see who the Commission has jurisdiction over, and read this change in a way that would not be construed to expand the Commission's jurisdiction, because the Commission cannot do that by regulation. But I think one of the concerns that was raised by Senator Daley is that the use of this term in this place may create an implication that the jurisdiction of the Commission is being expanded, that the testimony from the Executive Director seems to indicate was not the Commission's intent. So it would be within the discretion of the Legislative Commission to decide whether this is a reg that they would like to ask the Commission to take another shot at, to see if they can work with LCB to find language that would not create that implication, but would still satisfy the agency's desire in this instance. And we'd be happy to work with them on that language.
Great, thank you. Mr. Killian, Mr. Armstrong, I know you are very well versed in all of these regulations and everything the Ethics Commission has on its plate. Wondering if you have any thoughts on that, or maybe to address that as a concern that's been brought up again today in light of some of the reasoning that we have had from LCB.
Thank you, Madam Chair. I still believe that using the term person instead of the public officer or public employee in that line, makes it clear that we have to process that's the individual who files or is the subject of that complaint, or who is with respect to whom an ethics complaint has been filed, or who files the advisory opinion. I don't know that extra clarification of person would be helpful in this case.
And I certainly appreciate that. I understand what I think the Ethics Commission is trying to get at, and certainly respect that, Mr. Armstrong. I think there is some concern on part of this commission that because it could be read either way, that there's still some angst over, certainly that you may read it that way, or that the folks who are currently there may read it that way, but in the future it could be, because it could be subject to different interpretations, and maybe there's a little bit more finesse that could be added to the language. And then I think some additional concerns that maybe we can have some conversations with on some of the reports, and and making sure that we're clear on the anonymous piece. I understand that would require, I believe, a statutory change in order for you all to be able to kind of take jurisdiction over those anonymous reports. But I think maybe some additional conversations could be had with respect to how we protect whistleblowers and ensuring those complaints can still come forward. I think in terms of the regulation, though, there is some concern with the commission over who is trying to be captured within that definition of person, and making sure that it, as much as I think you are absolutely reading it correctly and have a good understanding of that it, because it could be open to multiple interpretations, that we would want a little bit more certainty in that language. So I think at this point, what I am going to ask this commission to do is to defer this back to you all to kind of work through a little bit of that, and ask that you have some conversations with members of the commission who've expressed some concerns today, and then work with LCB to hopefully get just a little bit more finesse with that language over who you're trying to capture, and in hopes that we will see this regulation back at a future commission meeting.
We can do that. Thank you very much.
Okay, thank you so much, Mr. Armstrong. I truly appreciate you being here today. Okay, members of the commission, that will take us to our next regulation on the agenda today. It is R017-24 for the Board of Massage Therapy, and we will allow them to join us wherever they may be. I think we might have them remotely. Nope, in Carson City. My camera angle just isn't quite big enough to see you coming from the other side. So we'll let you get situated. And then this one, I think, was pulled in regards to some of the commentary that we heard during public comment, and especially the concerns. And what I am very interested in is, and I sort of took another look at the regulation after some of the public comment that was offered here today, that there may be students who are currently enrolled in this program who have paid for, maybe potentially have done some of already for this ITAC program, and that, or that they may, be getting their results and sort of on the precipice of getting a license. And there doesn't seem to be any addressing of folks who have previously relied on that, or what a timeline might look like, or whether the plan is to grandfather folks in. So can you talk a little bit about two things? One, why the removal of this particular program? And two, with the removal, how that will impact any of those individuals that might be within that pipeline of potentially entering into that program or finishing it and going to be getting their license.
Thank you, Chair Canizaro. I'm Elizabeth Barnard. I'm the Executive Director for the Nevada State Board of Massage Therapy. So, a little bit of history. I know you guys have had a lot today and still have quite a bit to consider, so I don't want to take too long, but I do want to try to answer some questions. So, this exam was approved by the board in 2018, and at that point, the board thought that other states would be adopting it and that it would meet the qualifications of NRS 640C 582B, which include that an applicant for a license for massage therapy needs to pass a nationally recognized examination, basically to prove their competency. So one of the things that I think is kind of happening in this discussion and concern with public comment is this idea of education and examination are getting conflated a little bit. So the schools that currently offer this exam have expressed their concerns. The education those students still get at those schools will be valid. The question about the exam is that it would no longer be accepted. In the public hearing on May 9th, the board did discuss this. Part of the reasons that they chose to not include any extension when the motion was made to adopt the changes to the regulations were due to concerns over the security of the exam as well as other irregularities. Just as a comparison, the other exam that's currently in existence that's offered and that we accept is administered at secure testing sites. This exam is administered at 2 schools in Nevada, and those are actually the only 2 schools that this exam is administered at in the country. So right now, Nevada is the only state in the country that recognizes this exam. So back to the history lesson, in 2018, we thought more states would be coming on board, but that has not happened. I know for sure 2 states have considered it and denied it, just over other concerns.
So let me jump in here and ask a question. Why approve an exam in a regulation if it was entirely dependent upon whether other states would be adopting this? Because essentially now we are setting up in regulation folks to be in a position where you're approving an exam saying, yes, this will qualify, yes, we're going to accept this. But it is dependent upon the actions of other states to have adopted it, which did not happen when, and was not the case, when that exam was allowed by the board. And now after the fact, when folks are signed up for that exam, because it was an allowed examination as adopted in regulation, we're gonna pull that because other states didn't do the thing that we were hoping that they would do. It just creates a lot of uncertainty, and so I'm just curious, like, what is the thought process behind doing something like that when it could leave people in a precarious situation?
Elizabeth Barnard for the record. So I don't think we're pulling it just because other states don't recognize it. That's one piece of the puzzle. The fact that the administration of the exam and when there have been questions over the security of the exam, and I've tried to speak to the company that administers the exam, there was not much done as far as investigation. So in the interest of protecting the public, the board thought it was.
Wouldn't that be within the board's purview to oversee that and to conduct an investigation if you think that there's an error, potential safety concerns or security concerns or whatever sort of concerns there may be? Wouldn't that be within the board's purview to actually take some sort of investigation or action on?
Respectfully, no. We basically, that's why we cite other examinations in our regulations, so that we are not ultimately responsible for all of that. So we need to verify education and that they've successfully passed an exam Colleen, do you want to chime in on the legal aspect of that?
Thank you, Madam Chair. This is Colleen Platt for the record. I'm legal counsel for the Board of Massage Therapy. The issue with regards to the investigation into testing irregularities or concerns about the test itself are really, the jurisdiction is the administrator of that exam, and the board is not the administrator of any of these exams. They just accept them in regards to determining whether the licensed applicants have gained the requisite education.
So why approve? I know I'm probably getting into the weeds here, and really, because I'm just trying to understand like where this would, in theory, leave students who have now gotten into this position, right? You all, in regulation, approved a particular examination without any sort of idea of whether or not it was acceptable. If there were security concerns, you have no oversight, but you approve this exam, and you see other states are not approving it. Now you have all these questions. You're going to remove it. But in the meantime, there are students who are now in these programs. Like, where does that leave them?
Thank you, Madam Chair. Colleen Platt again.
Because this all sounds like it's not like, well, you know, standards changed or there was this significant shift. It was, we just randomly approved this as one of many types of programs. It's up to the companies to administer it. We didn't think they were doing a great job. We have no oversight. So now we're just going to say we're not going to approve that examination.
Thank you, Madam Chair. So back in 2017, when the board was looking at the exams that it accepted with regards to competency, the ITEC exam is actually administered internationally, so it's it's used in international countries, I think. England, I think the UK uses it quite a bit for their competency. And so in an effort at the time for the board to offer an option to applicants, this was an exam that was added. And at the time, they used that international reputation when it was analyzing whether to accept this as a competency with regards to massage therapy. Does it have other things too?
They test for many things, yes.
Yeah, so in addition to massage therapy, they do also test for some other things. And so what has happened is certain schools within this state have now have incorporated that exam into their own curriculum. So those students will go to the massage school, take that coursework, and at the end of that program will then take the ITEC exam. Over the last year or so, questions regarding whether or not that test is in fact safe in regards to that the individual is in fact the individual that says that they're taking the exam. And then regards to the test security and efficacy of measuring competency have come into question. And so when we've reached out to the administrator and asked, not the schools here, but the actual administrator of the exam in the UK, they've not taken any steps to mediate that concern. And so the board has some severe concerns that individuals are not, the individual taking the exam is not the individual coming for the license. In addition, there's some concerns that it's not really measuring competency as well. So after taking a look at that, the board's decided we want to make sure that those individuals that are coming as applicants have the competency and are not going to injure anyone while they're performing massage. Those individuals, the applicants that are currently enrolled in the schools that we're making public comment today, still have the option to take a different examination. There are still three others? One current. There's one other exam that they can take. And so it's not that they're prevented from continuing on and obtaining a license, because remember, their education will be accepted. It's whether or not they want to shift and take that other examination.
But what happens then if they're in the process of undergoing this particular examination? Now they would have to stop that and do a different one because we heard in public comment, and there are folks who are in the pipeline for this who are now sort of left in this unknown where they've paid for or are part of undergoing this. And if we pass this regulation today, tomorrow they would sort of be out that money, out that spot, and have to go find a different place. So what do we do with those students?
Thank you, Madam Chair. Elizabeth Barnard for the record. So with the knowledge that this was coming up, our licensing team has been trying to process as quickly as possible and kind of jump people that were applying under these qualifications, just this exam, to the front of the line. I saw the public comment that was the written comment submitted by Mr. Kennedy. Of those, I think there's one that has not applied. 2 had been approved. And I think, let me double check. I had notes on everybody. I think that leaves 3 pending. 1, we were waiting on their background results, which we're not able to speed up the results we get from DPS. Administratively, what we're considering is that we would not deny their applications. We would reach out to them and say they have the option to consider another exam if they would like. Previously, both the schools that currently use this exam, the ITEC exam, were teaching to the MBLEX exam, which is the other exam that's currently available. And they seem to have good pass rates. And it was commented during the public hearing that we have lots of students coming in with limited English proficiency that still manage to pass this MBLEX exam. So we would extend basically the open time of their application and allow them to submit results of a different exam to us.
But they would have to pay for and sign up for whatever they might need education-wise in order to do this other exam.
Sorry to interrupt you, Madam Chair, but no, their education will still be valid. This will not invalidate their education at all. There are 2 components, well, 3 components to our licensing process. So they have to have education that meets the requirements, which these schools are in Nevada, so even moving forward, it still will be an approved program. So we will still accept their education. They have to complete a criminal background. So that has to be clear of anything that would affect their ability to safely practice massage. And then they have to pass an entry-level examination proving that they have that competency at the entry level.
But if they already paid to take this exam, they would then have to pay for the other exam to go ahead and take that one.
That is correct.
All right, I think I'm gonna turn this over to Assemblyman DeLong, because I think you had a question, so we'll go to you next.
Thank you, Chair. Appreciate it. And again, appreciate you being here in person. Thank you very much. My recollection is that last session, the legislature passed statute that brought Nevada into the Interstate Massage Compact. I think we're a state in that compact, I believe.
We are the first. We're
Yeah,
waiting
I understand
for
that.
other states.
And so my question is, does the ITEC exam actually meet the standards of the compact, which we said we would abide by?
So the compact is an option. So we didn't have to raise the standards to meet the compact to be part of it. So the standards we had when that legislation was approved were fine. So two big things are happening in this reg change. So one is we are increasing our minimum hours to 625, which will help new graduates from programs in Nevada qualify for that compact licensure immediately upon graduation. That also is addressing a concern that some changes to funding federally for education and loans were going to be interrupted potentially for any programs less than 600 hours. So that was the other piece, addressing that Title IV funding, if I'm remembering the. Access to the federal loans, basically. So that's a piece of it. And then under the compact language, the language is pretty similar as far as that it has to be a nationally recognized exam. At this point, the only nationally recognized exam is really the NBLEX.
Okay.
So this regulatory changes actually helps ensure that graduates moving forward will be eligible
For the compact.
for the compact as well as for federal funding.
Great. Thank you very much.
You're welcome.
That was
Thank
my
you.
only question, Chair.
Okay, thank you. I see Assemblywoman Hanson, you have your hand up, so we'll go to you next.
Thank you, Chair. Thank you, Ms. Barnard, for being there in person. Sorry, I'm not. Assemblyman DeLong covered some of my questions. So the test that we do have in place, not this one that we're talking about getting rid of, is a nationally accepted standard test. Did I understand that correctly?
Executive Director Barnard, for the record, yes, of the 47 states that currently regulate massage, I think all but 2 of them accept this exam. And one is a state that does not require an exam, but they don't require licensure either. And then the other one is New York, which has had their own exam for quite some time.
And Chair, if I could follow up real quick. If that's okay, Chair.
Yes, please, go ahead.
Okay, sorry. I think when we talk about, well, in 2018, this test was accepted, and now we're looking at repealing it. I think all of us here as legislators can attest to the fact that we have passed legislation in the past that then we have had to come back because it had some unintended consequences. And I see that as what we're dealing with here. And also the idea that these students, their education is preparing them for a test. And it sounds like it's an education that will prepare them fine for the nationally accepted test. And I think it's so important that we know that massage therapy has worked, done the work to create an environment that doesn't have any appearance of nefariousness. I think they have fought hard to overcome stereotypes. And I applaud any effort, especially in this regulation, to ensure that those that choose to go into this as a profession, an honorable profession, that they have good education programs, which it appears that we do, a certain amount of hours, which looks like we're increasing to increase the product and the productivity of our graduates, and that it's done with a test that we can feel completely confident in, that's a nationally accepted test. I know as a member of education, during session and in the interim, we have visited and we've passed legislation to eliminate some tests for our teacher recruitment. And whether it be to make it easier or whether we have testing to improve a standard. So I frankly am fine with this, Reg. If we have a way to make sure it looks like you're tracking students who might be caught in a little bit of a gap here, it looks like you're paying attention to that. And perhaps how many students are we talking about that might be caught in this gap? Would you happen to have that number? And that's all from me, Chair. Thank you very much.
Thank you, Assemblywoman Hanson. There was a spreadsheet that my team was monitoring of what we had as far as results from the exam versus who had actually applied and where they were at in the application process. And I want to say there was about 30 names still on that list. But that was, there are a couple that, like I said, I know we were waiting on background. Some of them did not complete their application. And some of them we have not received an application from at all. And that happens from time to time. Someone will complete a program, take an exam, and decide they don't want to get licensed in this state, and they may have moved somewhere else.
Thank you.
Okay, Assemblywoman Backus.
Thank you so much, Madam Chair. I have two questions. One, I'm trying to wrap my head around, I know you said that there is one examination that is accepted, but when I look at Section 2, which references NAC 640C.050 for the acceptable exams, there's actually 4 exams set forth there under where there was originally 5 with the ITech removed. And I was just kind of curious if some of those other exams are just no longer being offered, or why that is.
Thank you for that question, Executive Director Barnard, for the record. And that is correct. So those exams were available in the past, but are no longer being offered in that current format.
And Colleen Platt, for the record, again, and as a follow-up, the reason those are not removed, even though they are no longer administered, is that individuals in other states could have taken them while they were being administered and then relocate here and seek a license. And so we need to make sure that those exams, which were nationally recognized at the time that they were administered, still remain on the books for us to take and accept.
Okay, thank you for that. I was just kind of confused when I just kept hearing that one exam and I saw the multiple ones there. And I guess from deductive reasoning, and I do believe you had said it, that the ITech is now no longer one of those examinations that would be offered in another state that we would be looking to give, I guess, full faith and credit to in the state of Nevada.
Executive Director Barnard, for the record. I'm not sure if I fully understood your question, but basically no other states have ever recognized this exam. So we don't really have to worry about anybody moving from another state with this exam as their credential or as part of their credentialing process. Did that answer
Okay,
what
and
you're
thank
asking?
you for that. It did, and I do believe you did say that earlier today, so sorry about that. I was just kind of thinking just the removal of that one. And then my other question for you guys is under that Section 12. I'm trying to kind of wrap my understanding of that because it does kind of give a grace period, but that grace period is basically 12 days from today. For those that are enrolled in a program and looking at the prerequisite of number of hours to be completed and then the specific number of hours in subspecialties or specific areas of study. And I'm just trying to understand what this grace period is recognizing it. Is it recognizing those that are students that are currently enrolled in a program, or is it just merely giving those individuals enrolled in a program 12 days to basically complete the program that they're enrolled in to be recognized?
Thank you for the question. So that grace period gives that time frame for somebody to be enrolled in that program. So if somebody enrolls tomorrow in a program that's only 550 hours and completes it, we would still recognize it. That's, yeah, okay. And the changes and those hours, the timing on it was to line up with the impending changes from federal funding, so that schools that were offering federal funding would still be able to receive loans and extend those out to the students that needed that to complete their education.
I just want to clarify what you had said at the end. If someone enrolls in a program tomorrow, there's no pressure for them to complete the program in 12 days. The grace period up until June 30th, 2024 will recognize any students that are currently or enrolled in a program before June 30th, 2024. They don't have to complete it before June 30th, 2024. Is that my understanding?
Thank you, Madam Chair. Colleen Platt for the record. Yes, the idea behind this 12-day June 30th ties up to the rule being implemented at the national level, wherein come July 1st, students who are enrolled in these programs will not be able to access federal loans unless they're in a program that has these 600 hours as a minimum. We have one school here, I think, that only has our curriculum of 550 hours. So we will accept individuals that enroll in that school on or before June 30th of this year. So if they enroll in that school and complete their program, it's usually about a 6-month program. And so 6 months from, let's say they apply in December 31st, we would accept that 550 hours, even though, as of today, if you approve this regulation, the hours would shift to 625.
So can you walk us through, because now we talked about a few different pieces of this, for folks who are currently in like a program where they were anticipating taking that ITEC exam, or those who've taken that exam, how does this regulation impact them?
Colleen Platt, thank you, Madam Chair. If someone is currently enrolled in a program, I think it was FUSUBA that testified today. So if Sally Sue is enrolled in FUSUBA today and is scheduled to take the exam, maybe she took the exam June 1st. If she took the exam and now is completing her program and submits the application, it depends on do they submit it before? Sometimes they submit the application before they have the results of the exam or they have taken the exam. So it's really kind of a case-by-case basis. But if they have taken the exam and submitted an application, the board will process that application even though, because they've submitted it before this reg was passed. Anyone who submits an application after today who is enrolled in any program will now have to take the MBLEX, because that's the one national exam that is currently administered. If they were in FUSUBA and they didn't sign up to take the exam, then now they will sign up and take the MBLEX. If they signed up to take the ITEC exam but didn't, then they'll have to cancel that exam and then reschedule and take the MBLEX. Does that answer your question?
I think so. And I'm gonna try not to mix the two, because we talked about there is a grace period for folks who are enrolling in programs who will not have to complete the 600-hour requirement if they were in a program that's less by June 30th. But for everybody else who's within that application and exam timeline, there is no grace period. It would, if we pass this regulation, it would end today. They would be out whatever that money is, or they would be out whatever that is if that application is not in, and have to go and then reapply and take a different test.
Thank you, Madam Chair. Colleen Platt. Yes. So the rationale behind the grace period for the curriculum, right? So the change. So currently we have a curriculum requirement of 550 hours. And they revised it to 625 after extensive discussion, not only amongst the board members themselves, but with the Commission on Post-Secondary Education. And then in looking at the compact, right, the compact requires at least a minimum of 600, and in 625, excuse me. And so in review of that, And then on top of it, you have the federal rule coming into effect July 1st, which requires a minimum of 600 hours. So the board recognized that it's revising its curriculum, the various courses that are required, right? So it's different numbers of hours for different subjects. And someone could have been enrolled in a program already that's 550 hours, or even if it was 625 hours, maybe the hours are apportioned differently. And so we recognize that we had to change the number of hours in order to allow students to still be able to continue to access federal loans for these programs. But we wanted to give the individuals who are already committed to a program on the path to a 550 hours, we wanted to give them that ability to continue and finish that program without theoretically a penalty. Now, when it comes to the exam, they did have a discussion about doing this, about allowing this grandfathering in for a period of time. But again, they went back to their mission is, when these boards are dictated to regulate in the benefit of the public, right? And so if the mission of the board is, I'll turn to Ms. Barnard for the mission of the board.
The mission of the Nevada State Board of Massage Therapy is to protect the public health, safety, and welfare through effective massage therapy regulation, ensuring that qualified, competent, ethical practitioners are licensed.
So when that's the mission of the board, and you're,
I think that the question that we're trying to get to is what happens to these students who up until today were in a program and signed up to take an exam that was recognized, that tomorrow will not be, and like practically speaking, logistically and practically, like where does that leave them? Because I don't think anybody's taking any issue, like you guys don't want to do the ITech exam anymore, fine. But for students who up until today, that was an approved course of action, right? Not because they said so, but because the board said so. Mm-hmm. Now tomorrow, that's not the case, and they have to try to figure out, like, how do I pay for this? What are the next steps? What if my application is in? Like, that's what we're trying to get at. And there are parts of this where there was some grace given for certain programs, right? Where if tomorrow they sign up for a program and it doesn't meet the new hours that are part of this regulation, that's going to be given the grace period until June 30th. But there are students who are falling in this gap, and no one's questioning the board's ability to regulate. Like, certainly the legislature understands the importance of and the significance of and why we want to regulate people and the health and safety and all of that. But like, what happens to those students? That's what we're trying to get at.
Thank you, Madam Chair. Executive Director Elizabeth Barnard for the record. So I communicated with both the schools that currently offer this exam, advising them of what legal counsel had told me as far as when this would be effective and also the date of this commission meeting, so that they were well aware of what the timelines would be and when this exam might be being removed. So if they...
But this commission could either approve this regulation, send it back to you all, or just deny it outright.
Right. And I understand that.
Why not build in a grace period for those students as well into the regulation?
I believe the board did not do that because they wanted to ensure proper public safety. So at one point, Las Vegas Metro PD had asked me for a list of all of our licensees who had taken this exam because they wanted to match it up against prostitution arrests. Because they were seeing a trend.
I understand all that. I was a prosecutor for a very long time.
Okay.
The question, though, that you are prompting before this commission is that there are students who you are saying if there is an application in and that's the exam they took, you all are going to acknowledge it. But if they didn't get in the application tomorrow and they were going to do it tomorrow, now they're out of it. And so I'm trying to figure out, practically speaking, what happens to those students, because prior to today, that exam was acceptable.
Mm-hmm.
So, like, what happens to those students is the question. Not why this happened, different things that are ongoing, why you don't like the exam anymore, why there might be some issues related to that, why there might be safety concerns. I understand all of that. I think we all do. We're trying to get to the point of like, if we approve this regulation and we vote for that, there are students who are going to be out money, fees, exams, etc. And what happens to them when in some cases we're willing to give some sort of accommodations and grace periods, but for this particular set of students who don't have an application in already, but are taking the same exam as somebody who may have gotten an application in yesterday, are now going to be left in a position where they have to go and sign up for another exam.
Madam Chair, that is correct. They will have to take a different exam.
Okay, thank you. Senator Harris.
Thank you, Madam Chair. I have a couple of questions. I hope that'll all flow together at the end here. So can you tell us how much does someone pay currently to take the exam that we're getting rid of? I think it's referred to as ITech, is that right? What's the fee for that?
One of the people present there from one of the schools in Las Vegas would be better able to say. However, I believe it's around $350, give or take.
And are these fees paid directly to the, I guess, the exam company? So would these folks have paid ITech directly? Or are these facilitated through you all?
No, we do not handle any of the exam fees as a board. I know for the MBLEX, those fees, I believe, are paid directly to the Federation of State Massage Therapy Boards. For ITech, I don't know if the schools handle that and then submit on their behalf, or if it's paid directly to ITech.
Okay. Is there any practical issue with I guess because you guys don't handle the fees. Right, so we can't get anybody any refund that's already paid for the exam, right? So is there any way, are there practical issues with drafting a regulation that would say, if you've already signed up and paid for the exam prior to the change, we will accept that exam? Prior to today's date. I mean, I guess you'd have to maybe go back and redraft it in order to do something like that. But would that be practical? Because I think that would address some of the concerns that you're hearing from the committee. You'd still have a clean cutoff date. As soon as the regs are changed, if you sign up for the test or after that, we're not going to take it. But if you can come and show that you paid to take the exam before the regulations were changed, we'll take it. Is that something you all could consider?
Executive Director Barnard, for the record. So just to clarify, are you asking if you remanded these reg changes back to us, if we could make that adjustment? So that would then interfere with the schools that need this help to get federal funding.
And that would be because we've run out of time, correct?
Correct, yes.
Okay.
So the one thing to kind of answer your question about refunds and all of that stuff, I would suspect the schools could maybe reach out to ITech on behalf of students that had signed up and won't have that exam considered now. That would really be up to the schools to see if that's possible.
Okay, I'm trying to help you get your regs out today. So
I appreciate that.
we gotta talk about but in order to do that, I need to know about what you all are willing to do. So is there anything that you all could do, absent a change to the regulations, to address this gap for folks? Maybe waive a different fee or something in order to kind of ease the cost burden of someone having to pay $300 for one test and then bing, bing, boom, tomorrow having to pay $300 for another just because they didn't take the test in time or whatever the case may be. Any suggestions?
Colleen Platt for the record. Possibly, if you approve this regulation today on trust and faith that we would have a meeting of the board, we could theoretically adopt an emergency regulation, which would be valid for 150 days, whereby we allowed a grandfathering period for a certain period of time. Of course, that would require, I'd have to look at what I have to do for an emergency reg, how many days I have to post, but that could be done. But I believe it requires the governor to sign, so I'd have to get his signature.
Okay, well, it's nice to know that we have that option in our back pocket. Thank you for riding along on that ride with me. I think we've ended at a good destination. I wish you the best of luck on getting that reg passed.
Senator Stone.
Thank you, Madam Chair, and hope you feel better soon. And thank you for allowing me to ask a couple of questions. So right now, prior to the change in the number of hours, I think it's 550. I think you mentioned was the older number of hours that a massage therapy student would be needing to get licensed. So, I got a real estate license, and when I was looking to go to real estate school, I wanted to go to a school that had the highest pass rate, if you will, that really prepared you for a test. So when you have 550 hours versus 625 hours, one could assume that the test is going to be somewhat different. And you have these students that have been studying for 550 hours expecting one test. And in addition to the financial burden, are going to have to figure out what additional coursework is necessary for the public safety that you talked about. And we're always looking to improve our schools and make things safer for the constituents. But I agree with the chair and the vice chair that we should have some grandfathering in for really, based on the number of kids that you talked about or adults that you talked about, are we talking about 20 or 30 people? And are you telling me that you don't have the capability of just grandfathering these people in that are having the 550 hours of education to take the ITech test? And anybody that applies after June 30th has got to go for the 625 will be taking the new test. Are you incapable of doing that under present policies and laws in the state of Nevada?
The short answer is yes.
Then let's do it.
So we do try to follow the laws and the regulations, and I think we do that so far. And absolutely, I can take this to the board and ask for an emergency regulation to do that grandfathering piece. And then what we'll do is just put all of the people who are applying with an ITech exam kind of on hold for the moment until that kicks in, and then we could process them and complete their applications.
Just to follow up, I think we should honor our promises, if you will, to students and say, this is a 550-hour curriculum. This is the test that you're going to be taking. I understand there's a new test. I understand there's more hours, but we should live by the rules that we sign up with. We shouldn't have to pull the carpet out underneath students to say, well, we're going to go ahead and go 625 hours, which means the curriculum is going to be expanded, which means the test is going to be expanded, which means there's a possibility if I don't put in another 75 hours that I could have potentially flunk the test. And I don't think that's what the schools want to do. So I think we should hold people of the rules at the time that they signed up. We're talking about 20 or 30 students. I don't think it's that big of a deal. We had to grandfather them in and move forward with your new enhanced curriculum and do what we can to make it safer and more professional for massage therapists to give their appropriate services to our constituents. And if you're able to commit to that, I'm happy to support the regulation with the understanding that these people are going to be protected. Thank you, Madam Chair.
Thank you, Senator. Assemblywoman Monroe Moreno.
Thank you, Madam Chair. And hearing the comments from the senator up north, if we were to do that and these students are grandfathered in, being what you said earlier that the requirements are changing at the federal level to more hours that would be required for licensure. Would these 30 students only be able then to practice here in the state of Nevada? If they were to go to another state, they would have to have that additional training before they could get licensed in that state moving forward. Is that a correct assessment?
Not necessarily. Most states, there's a patchwork of different requirements amongst the states, ranging from about 500 hours to 1,000 hours. So it really would depend on what state, any sort of reciprocity happening in the other states, all of that. And one of the motivating factors behind this increase in hours, as well as the removal of the ITEC exam, is to make us a little more in line with other states, which also gets us in line with that national compact once it stands up. The 600 hours is for the federal funding for the student loan piece. Did that
Perfect. Thank you for the
clarify?
answer.
Okay.
It did. It did. I just wanted to make sure that they would be employable if they did choose to leave the state of Nevada and go somewhere else for employment. It answered the question.
And Madam Chair, if I may, in response to some of the questions that I had with regards to creative thinking around here, July 1st, I believe, and LCB can correct me if I'm wrong, Mr. Killian can correct me, I believe July 1st starts the temporary reg adoption process, and so I wouldn't have to do an emergency reg and get it signed by the governor. I would just follow the standard temporary reg posting requirements. I believe even there, you have the ability to pull the reg for review to make sure that we are doing what we said we would do.
You are correct that the temporary regulation process is about to begin, but it's August 1st, not July 1st, so that would be an additional 30 days or so, and I'm not sure how that complicates things or doesn't complicate things. I think kind of after a very lengthy discussion, here are my thoughts. We're in a bit of a tough situation because we have a regulation before us that, if not adopted today, which I extraordinarily hate being in this position, where we get a regulation that if we don't adopt, we're out of alignment with federal standards, and this has other implications that are broader than just what this commission has the authority to do. It is exceedingly frustrating to be in a position where we have a reg before us that has those sorts of implications, that if we do not pass it, there are other ramifications for things that are outside of our control. And because it sort of puts this commission in a position where we sort of have to do it, or deal with all the additional outfall, some of which we don't have control over, like federal funding. We are at the state level, and beyond that, we are not a legislature that is in session. We are a legislative commission that can either approve or deny regulations. And so when we get a regulation that is missing or lacking some pieces that we would like to see, but yet has other pieces that we absolutely must pass in order to meet guidelines that are outside of our control, even if we were in a legislative session because they're federal in nature, that is an exceedingly difficult position for all of us to be in, because we did hear public comment, we did hear from the students, many of whom were here in Las Vegas today, about the uncertainty and frustration that come from one day being able to have been in a program and in a situation where this was an allowable exam. And I understand you can find issues with exams and say, well, this wasn't working or that wasn't working. We have all been through the regulatory process where that's been the case. We've been in the legislative process where we're being asked to pass bills to address certain issues that come up. No one questions that as a legitimate thing for this board to be doing, and certainly a legitimate use of the regulatory structure and this commission. However, we do not have an opportunity as a legislative commission to amend regulations as you have seen today. We either have to defer them entirely, which will leave us outside of that federal deadline, or we have to adopt them or deny them entirely, which starts the entire process all over again. I want to be very clear that I expect to see a process, and I will make the appropriate calls I need to make to see about whether we can get an emergency regulation to make sure that there's some clarity for some of these students, because I think it is It's disappointing that there wasn't also some grace period put in here in the regulation. Not like, hey, we're bringing this, it's going to go before legislative commission that's going to get scheduled for some time in June. When that meeting is set is sort of dependent a lot upon who's available here to be able to come in a June meeting. So that is not a lot of clarity for folks. I expect that the board will take the appropriate action to engage in whatever sort of waivers they can for fees and for students, and to be gracious with the applications that are coming to you for folks who relied on something that today is an allowable exam and process, and that tomorrow may not be. I also expect this board to engage in that emergency regulatory process, because as much as I think the temporary reg is a good idea, and that's kind of where my thought went, August 1st is a long period of time. It probably doesn't solve that issue in the way that an emergency reg could. My promise to all of you is that I will make a call and request, some of this being outside the hands of the Legislative Commission and the legislature, but I will make a call to see if we cannot get some support in order to help that process take effect, so that there is some ability for those students to have clarity and to not be out of a whole bunch of fees, or to find themselves in a position where now they have to go and retake some courses in order to get to a particular position due to no fault of their own. And so we're all going to move forward with a lot of faith and good dealing between one another, that we will make this work in exchange for the fact that we know there are pieces of this regulation that have to be adopted. That's kind of my thought to this commission, is to approve the regulation, but to do so with the board's understanding. And I'd like for you all to just say, like, that sounds like something you can do. That you will engage in that emergency regulatory process, that you would give grace and find ways to be creative with fees and being flexible, that to these students who may fall into this gap, that you do what you need to do, and that the schools do what they need to do to get those students to a place where they need to be, so that they're not out all of that. I think we can find a resolution that way for this particular issue, and in the meantime, allow the portions of this regulation that need to go into effect for other reasons to actually do so. And if we can all agree to do that, that'll be my promise to you all. And if the board is in agreement, then that to me kind of feels like maybe the right place for us to go today.
Madam Chair, Executive Director Barnard for the record, and I believe we can do that. Absolutely, I've been trying to, as I stated early on, we've been trying to work with all the pending applications that we could to move them through so they didn't get caught up in this. We just still had a few stragglers, and I understand the ones that maybe still were in the process of completing their program and still needed to apply. And I will defer to our legal counsel and to your direction as far as the best step to take in that process. If an emergency reg is the way to go, then I will put that to my board, and I hope that they will be amenable to it.
And I appreciate that. And I do appreciate and I do acknowledge the work that was done to try to get some folks to that place. I just fundamentally think when we change things one day to the next, that creates uncertainty that's not fair to folks who maybe weren't aware for whatever reason or another. So I appreciate your willingness to kind of work on all of that. Members of the commission, thoughts? Do I have a motion to approve?
Chair, I move we approve Regulation R 017-24A.
I have a
Promises
motion from
expressed, I second.
Yes. Thank you. I have a motion from Assemblyman DeLong. I have a second from Senator Stone. Any discussion on that motion? Senator Harris.
Thank you, Madam Chair. I think you outlined well what it is that we all can and need to do in order to assist the students. But I do just want to also comment that I expect the schools to also do a little bit of sweat equity to help the students as well. I don't know how much they paid you, but I'm pretty sure they paid you to help them get through this process. And clearly, we're not accepting this test anymore because of what seems like very valid reasons. And so whatever you all can do to advocate on your students' behalf to get refunds so that they can sign up for the proper test. That company may tell you no, and I'm not expecting anyone to spend dollars suing anyone or anything like that. But we will all do our part, and I hope that you all will do your part to advocate for your students as well. Thank you.
Thank you. Further discussion on the motion? Hearing none, all those in favor, please signify by saying aye.
Aye.
Aye. Any opposed, say nay. Motion carries, and R017-24 will be adopted.
Thank you.
That brings us to our next regulation, R025-24, with the Peace Officer Standards and Training Commission. And we will let them get with us, and I'm going to turn it over to Assemblyman DeLong. You had a question on this one.
Yes, thank you, Chair. I'll wait for them to alight in their seats.
I think we may have them remotely.
On the phone?
Yep, there
Okay.
they are.
Oh, they are in their seats then. I just have a question. Why under section 1, I think it's 1.2F, why are we removing the state's physical fitness standard from the regulation?
Mike Sherlock, for the record. I'm the executive director of the Peace Officer Standards and Training Commission. This simply applies to reciprocity. At the same time, it does allow the hiring agency to administer a physical readiness test. But we, at the request of hiring agencies, we wanted to recognize that this applicant is already certified as a peace officer in that other state. And many states already have a physical fitness requirement or a physical readiness requirement. So this only applies to those applicants. Anybody certified, newly certified as a peace officer in the state of Nevada is still required to do the physical readiness test. It's just that often they've already done that in the state they came from.
Okay. Thank you very much.
It was a matter of recruitment and that sort of thing.
Okay, thank you. That clarifies it for me. Thank you.
Okay, thank you. Any additional questions or comments from members of the commission? Hearing and seeing none, do you have a motion, Assemblyman?
Yes, I do, Chair. I move that we approve Regulation R025-24A.
Great, and I have a second from Senator Harris. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Any opposed, say nay. Hearing none, the motion carries unanimously. R025-24 will be adopted. Thank you so much. We will move next to R047-24 for the Board of Public Employees Benefits Program. And I'm going to turn this over to Senator Daly once we have them with us. Which I think we may have them in person. Yep. So once they're settled, Senator Daly.
Hey, thank you, Madam Chair. So my question comes, and it's along a theme today, it seems like. So in your statement on why you needed the regulations, one of the things that stuck out to me is that on the things you're deleting, so several of them are repealed regulations whose provisions were otherwise addressed in statute, which is fine, were more appropriately addressed in agency documents. So that's where I wanted to get a little more information on what's going to go into agency documents versus what's already covered. So there's 9 sections that you're repealing. Some of them look straightforward. They might be about the, who votes and the director and the vice chair and all that kind of stuff. But when you're putting things in agency documents, what type of things are you putting in there if they were previously in regulation? Because I don't want to see mission creep. We're not going to go through the regulatory process. We're going to take that out of regulation. and we're just going to adopt it ad hoc in agency documents. And as you might guess, I'm opposed to that.
Good afternoon. This is Celestina Glover. I'm the Executive Officer for the Public Employees Benefits Program. And the things we're talking about putting into our agency documents, we have what we call a master plan document that outlines the benefits for the various plans that we offer. The things that we're looking at putting in there would be things like address changes or forms that we require the members to submit. If they need to make a change to their plan or if they need to add dependents, things of that nature. So we felt like the master plan document clearly outlines what kind of information we require. It also outlines eligibility for the plan, things that include the list of benefits, documents required, all of those types of things. That's the only thing we're looking at putting in plan documents.
And I understand, and that's kind of what I wanted to get on record. Do you guys have to do, I know like private health and welfare plans, like I'm still a trustee on the one for my union, have to do a summary plan description type document that you have to submit to or send out to the participants. Every so often the feds make us do it. Do you guys have to do a similar type of thing when you're talking about dependents, re-enrollment, those types of things?
This is Celestina Glover for the record. We do have a what we call the summary benefits documents. We also have the master plan document, which is the complete document, and we also have a comparison guide. We post those out on our website, but if somebody would like something in hard copy, then we will mail that out on request.
Understood. And I was just trying to guard against the mission creep on, what needs to really be a regulation, something that's a general application, as you guys know, that needs to go through that. Eventually, if you went too far, there would be a complaint and ad hoc rulemaking, and it would potentially get struck down. So I don't think you have any interest in doing that, but I want to make sure you're not as well. So that was my question on that, on what type of things we were going to put into agency documents, and that if it's appropriate for a regulation, we expect that to go through the regulatory process. That was all I had, Madam Chair.
Any additional questions or comments from members of the commission? Okay, I am seeing none. Senator Daley, do you have a motion you'd like to make?
Yes. I would move to approve R047-24.
I have a motion from Senator Daley. I have a second from Assemblywoman Backus. Any discussion on the motion? Hearing none, all those in favor, please signify by saying aye.
Aye.
Aye. Any opposed, say nay. Motion carries unanimously. R047-24 will be adopted. And that brings us to our final regulation of the day, R061-24 for the Administrator of the Division of Outdoor Recreation. So we will let them join us, and I will turn it over to Assemblywoman Anderson when they are ready.
Thank you, Chair, and thank you very much for being here in person. Also getting a chance to talk to you earlier today. My question has to do with the process that you're envisioning, in particular under Section 10, when you're changing the administrator's verification from every 5 years down to each year. My two questions: number one, is this going to be a self-reporting, or are you expecting members from your staff to go out and double check it? And then the second question is there already a plan to do auditing? I noticed that there is, the compliance is already listed, but is there a plan to do possible auditing in the future to make sure that the information that is given is actually accurate?
For the record, my name is Chelsea Kinchlow, Kincheloe. It's quite a long name. I'm the Program Officer 3 for the the Division of Outdoor Recreation. So thank you for your question, and thank you for connecting with me earlier today as well. So as to your first question about self-reporting, the way we're planning on implementing this is to have some type of form that our applicants would fill out and submit to us, and then we would verify that form, look it over, ensure that they are providing all of the materials that we needed, whether that be photos, receipts of upgrades to infrastructure or policies, and then if need be, we would go more in depth if we needed to follow up with them in addition as well. Does that answer your question?
It does, thank you. And I'll explain why I'm asking it. I'm concerned about us possibly, by approving this, 2 years down the road, having somebody come up and say, we need more people to double check this information. So it is, at this time, the plan is to have it be self-reporting, is what I'm understanding, and the application itself has not been completed yet. Is that correct?
Correct. And I would also like to note that we've only had within the past year one individual express interest in this program, so it's not something that we see as in huge demand yet.
I love the optimism of yet. And so at this time, you are not planning on doing audits or anything along those lines because there's not yet a need for it.
Correct.
Great. And then for that application, will that be looked at by anybody else, or is that you get to own it and it's just your application and how you see it?
Yeah, it's a good question. So it will be me reviewing, but should I feel like there needs to be additional oversight, I will include our deputy admin or our administrator, Denise.
Thank you so much for those clarifications, and thank you, Chair. I'm ready to give a motion if you'd like me to.
Are there any other questions or comments from members of the commission? Seeing none, then I believe I have a motion for approval from Assemblywoman Anderson. I have a second from Senator Harris. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Any opposed, say nay. Hearing none, motion is approved and the regulation will be adopted. Thank you so much for being here with us today. Members, that does complete our consideration of administrative regulations for this afternoon. Thank you, everyone, and thank you for everyone from our agencies who were with us to answer all of our questions. That brings us to item number 5, which is approval by this commission of the language to be included on the general election ballot in 2024 for ballot questions 1, 2, 4, and 5. That is pursuant to NRS 218D.810. I believe that we have Heidi Charlson, our Chief Deputy Legislative Counsel, with us in Carson City this afternoon. And I'm going to turn it over to her to proceed with our consideration of the language for ballot question 1. Members, you will also note that you have a hard copy of these materials in front of you as well. And for those of you joining us remotely, it should be available on the legislature's website.
Thank you, Madam Chair. For the record, I'm Heidi Clarkson with the LCB Legal Division. I'd like to begin this agenda item by just giving a brief overview of the process for preparing the ballot materials for constitutional amendments and statewide measures proposed to the voters by the legislature. After that, I will turn to the specific materials presented to the Commission for the 4 ballot questions. The process for preparing the ballot materials is governed by NRS 218D.810. Under that statute, the Legislative Council Bureau must prepare for any proposed constitutional amendment or statewide measure a condensation, which is the question that appears on the voters' ballots, an explanation and digest, arguments for and against passage, and a fiscal note. The ballot materials are required to be of reasonable length and written in easily understood language. The Legislative Commission is required to review the ballot materials, revise them if necessary, and approve them for delivery to the Secretary of State on or before July 1st. The approved ballot question materials are included in sample ballots. For purposes of this agenda item, it is important to note that the Legislative Commission is not being asked to approve or disapprove of these proposed constitutional amendments or statewide measures. That issue will be decided by the voters at the 2024 general election. Instead, the Legislative Commission is being asked to review the language in the ballot materials to ensure that it will assist the voters in making an informed choice. In preparing the ballot materials that the Commission has before them, the LCB assembled a team consisting of staff of the Legal, Research, and Fiscal Analysis divisions. The team met and conferred multiple times before finalizing a draft of the ballot question materials for public comment. The period of public comment began May 21st and ended on June 4th. After the 2-week public comment period ended, the LCB staff met again to revise the ballot question materials, taking into account the public comments received for each question, if any. Turning now to your meeting packets, there are 4 tabs under each ballot question that correspond to the sequence of the drafting process. Under the first tab is the joint resolution or bill proposing the constitutional amendment or statewide measure. Under the second tab is the LCB's initial draft of ballot materials that was submitted for public comment. The third tab contains the public comments received by the LCB, if any, in response to the initial draft. And under the fourth tab is the LCB's revised draft that is before the Commission for review and approval under this agenda item. The LCB's revised draft follow our typical drafting conventions. They use blue, bolded italics to show the language being added to the ballot materials based on the public comments. And they use red brackets and strike through to show the language being removed from the ballot materials based on public comments. After the Legislative Commission approves the final versions of the ballot materials, the LCB will format the language into normal fonts and text colors before delivering the finalized ballot materials to the Secretary of State. That brings us then to ballot question 1. Ballot question 1 proposes to amend the Nevada Constitution relating to the Board of Regents of NSHE. As I previously mentioned, tab 4 has the revised draft based on public comment for your consideration. The Legislative Commission can approve the revised draft as presented under tab 4 or make additional changes. I am happy to answer any questions that the committee has. Also, Haley Prohl of the Research Division and Michael Nakamoto of the Fiscal Analysis Division are also available for questions.
Thank you, Ms. Clarkson. Members of the commission, do we have questions or comments on the language that is proposed in front of you for ballot question number 1? I am not seeing any. With that, I would accept
Chair?
a motion. Oh,
Chair, I do
sorry.
have a quick
Go ahead.
question.
Assemblyman, go ahead.
Thank you.
Yes.
Just wanting to make sure I understand what we're seeing. Under the first tab, we've got the Senate joint resolution, but then under the resolve section and further resolve, we've got changes. And so are those changes that were part of the original joint resolution, or are those something new as a result of public comments?
Thank you. For the record, this is Heidi Clarkson with the Legislative Council Bureau. Under the tab that indicates ballot question 1, SJR 7, 2021, that is the actual Senate joint resolution that was approved by the 2021 and 2023 legislatures. The reason that it shows red and blue italics language following our drafting conventions is because this is how the bill was how the resolution was drafted and approved by the legislature. This version under this tab has no changes that have been made since passage by the 2021 and 2023 legislatures.
Thank you for making that clear. Thank you.
Thank you. Additional questions or comments? I'm not seeing any. I have a motion to approve the proposed language for ballot question number 1 in the revised draft as presented before this commission from Senator Harris and a second from Assemblywoman Backus. Is there any discussion on the motion? Seeing none, all those in favor, please signify by saying aye. Aye.
Aye.
Aye.
All those opposed, please say nay. I'm not hearing any nays. Motion passes unanimously and the language will be adopted. And we are going to go ahead and move on to ballot question number 2.
Thank you, Madam Chair. Ballot question 2 proposes to amend the Nevada Constitution to revise certain language relating to institutions that the state must foster and support. The LCB did not receive any public comment regarding our draft of the materials for ballot question 2, so we did not make any changes to the materials. The Legislative Commission can approve the language as presented under tab 4 or make additional changes. LCB staff is available if there are any questions.
Okay, do I have any questions from members of the commission on ballot question number 2, language? I'm not seeing or hearing any. Okay, I do have a motion from Senator Harris and a second from Assemblywoman Backus. Any discussion on that motion? I am not seeing any. All those in favor, please signify by saying aye.
Aye.
Aye. Aye.
Any opposed, say nay. Motion carries unanimously and the language as proposed will be adopted. And we will move on to ballot question number 4.
Thank you, Madam Chair. This is Heidi Clarkson with the Legal Division. Ballot question 4 proposes to amend the Nevada Constitution to remove language authorizing the use of slavery and involuntary servitude as criminal punishment. Tab 4 has the revised draft based on public comment for your consideration. I note that there is one inaccuracy that I need to correct on the record. In the arguments for passage, under tab 4, on page 2, line 7, the reference to 27 states should be 23 states. I apologize for the confusion. The Legislative Commission can approve the revised draft as presented on under tab 4 with that one correction or make additional changes. Again, LCB staff is available if there are any questions.
Great, thank you. So for members of the commission, that is a 23 instead of 27 on page 2 under tab 4. And any questions or comments on the language for this ballot question? I am not seeing or hearing any. So I would accept a motion to approve this language with that correction to 23 from 27. So moved by Senator Harris. I have a second from Assemblywoman Backus. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Any opposed, say nay. Hearing none, motion carries unanimously, and that will bring us to ballot question number 5.
Thank you, Madam Chair. This is Heidi Clarkson again with the Legal Division of the LCB. Ballot question 5 proposes to exempt diapers from sales and use taxes. Tab 4 has the revised draft based on public comment for your consideration. The Legislative Commission can again approve the revised draft as presented under tab 4 or make additional changes. And LCB staff would be happy to answer any questions the committee has.
Thank you. Are there any questions or comments from members of the commission? I am not seeing or hearing any. I would accept a motion to approve. So moved by Senator Harris. I have a second from Assemblywoman Backus. Discussion on that motion. Okay. Seeing none, all those in favor, please signify by saying aye.
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 All opposed, say nay. Hearing none, motion carries unanimously, and that language will be adopted. Thank you very much, Ms. Clarkson, for walking us through all of that. I appreciate your hard work and those who have gotten us to this point on those questions. Members, that takes us to item number 6, which is the appointment of members to committees and similar entities. There is a document in front of you, commission members, that does outline the individuals who are proposed to be appointed to the various boards and commissions for which this commission has us to approve. And I'm actually going to turn it over to Mr. Killian to walk us through the details.
Thank you, Madam Chair. Asher Killian, Legislative Counsel, and in the interest of time, I'm going to be brief in my description of these positions. I have more background on each of these bodies if the Commission would like to hear it or if there are any questions. There are 3 bodies for whom there are appointments before you for consideration. The first is the Advisory Council on Mortgage Investments and Mortgage Lending, for which there is 1 vacancy with a person recommended for appointment in the attached document. The second is the Commission on Minority Affairs. There are 6 names for this body. 3 of these are reappointments. 2 of them are new appointments to new terms. And 1 of them is an appointment to fill an unexpired term of 1 year rather than 2. Finally, there's the Southern Nevada Enterprise Community Board, and there are 2 members recommended for reappointment for this board. And I'm happy to answer any questions, or if any members would like any additional background on any of these bodies, I'm happy to provide it.
Any questions from members of the commission on these appointments? Seeing none, I would accept a motion to approve these appointments as recommended on the sheet in front of you. I have a motion from Senator Harris.
Second.
I have a second from Assemblywoman Backus. Any discussion on the motion? Seeing none, all those in favor, please signify by saying aye.
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 Anyone opposed, say nay. I thought I heard 1 nay. I don't know if that's a real nay or not, or we're just all getting a lot of sorts here. All right, hearing no nays, that motion passes unanimously, and those individuals will be appointed to the various committees as listed in front of you. That brings us next to item number 7, which is the approval of early session hires for the next legislative session, because it is just around the corner. This is a pretty standard agenda item for us at this time in the interim, but I am going to turn it over to Mr. Killian, who will be able to answer any questions that anyone may have about a request. We generally start the session hires about this time, so for those of you who've been with us before, it's time. Mr. Killian.
Thank you, Madam Chair. Asher Killian, Legislative Counsel, and you said most everything that I intended to say. We generally hire our first slate of early session hires around July 1st. So this is the typical timing for the first set to come before the Legislative Commission for approval. There will likely be at least 1 additional set coming at a future meeting, and I would note this is the first time we've got session hires to staff our significant new facilities in Las Vegas. So a significant number of the positions before you for approval today are for our first set of people staffing the first session for all of our buildings down here in Las Vegas. And I'm happy to answer any questions the Commission may have.
Members, any questions for Mr. Killian? No questions. Senator Harris, go ahead.
Thank you, Madam Chair. I am so thrilled to hear that a good portion of these positions will be located here in the southern part of the state at our new offices. I just would like to put it on the record and implore the Legislative Council Bureau to take these open positions as an opportunity to make sure that the legislative staff looks a little bit more like the rest of the state of Nevada. And I think we have that opportunity with new positions opening, especially here in Las Vegas. So hopefully we can start that process. Thank you, Madam Chair.
Thank you, Senator. Any additional questions or comments? All right, seeing and hearing none, all those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Any opposed, say nay. Hearing none, motion carries unanimously. All right, members, that brings us to the next item on our agenda, which is our second period of public comment. We'll be accepting public comment in person here in Las Vegas. If you're here to give public comment, take these seats in front of us, or in Carson City. It doesn't look like we have anybody who managed to make it to the end. But if so, and you're on the ends, come and take those seats. And as a reminder, please identify and state and spell your name for the record, and we will give you 2 minutes. Seeing no one in person, we will move to the phones. BPS, if you could connect us to anyone who may still be with us wishing to give public comment. As a reminder, 2 minutes for those of you on the phones, and happy to accept any written comments over and above that 2 minutes. BPS, when you are ready.
Chair, your public line is open and working, but we have no callers at this time.
I appreciate that, and thank you for your time and assistance in facilitating public comment. Members, that brings us to the last item on our agenda. It is adjournment. Thank you so much for being here with us today, and seeing no further business to come before this legislative commission, this meeting is adjourned.